Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
I'm trying to check everyone off my little checklist here. I feel like I'm missing someone from the plaintiffs.
He jumped on. He's right there, Mr. Register.
I see. Okay.
He was
Good
ready.
afternoon, Your Honor. Rob Register.
Good afternoon.
We had a little technical difficulty logging in with the meeting code.
I'm sorry.
No, it's not your fault. It was my fault for sure. I didn't capitalize the letters.
Okay. I'm assuming everyone wants court reporter to take down this hearing, correct?
Yes, Your Honor.
All right.
Yes, Your Honor.
I think she just posted a message in the chat to give you some instructions.
She did.
Do we need to make that payment now, or can we make it after we're done?
I think you're good until after we're done. We know where you work.
Okay.
We have some pro se folks sometimes we have to get it up front, but
We're good for it.
you're good for it.
Allegedly.
Okay. Okay. Miss Holloway, let me know when you're ready.
Ready.
All right. This is the matter of Kenneth C. Wilson versus Timothy Gattas, Todd Smith, and Ortho Atlanta LLC, case number 2024 CV 02531. This matter is on today for a pretrial conference. This case has been previously scheduled for trial to begin on March 16th, 2026. On behalf of the plaintiff is Mr. Rob Register. I see there is another attorney from the plaintiff's office, Mr. Larry Golston. Is that correct?
Yes, ma'am.
All right. Is anyone else present on behalf of the plaintiff?
My paralegal, Holly Titus, is on with us, Your Honor.
Okay. Thank you. On behalf of Mr. Gattas, am I saying it right? Is it Gattas or Gattas?
I believe it's Goddess, Your Honor, but I can't tell you that with any certainty.
Okay.
I talk to him and I say it both ways. And he never
Okay.
corrects me. So
All right. I don't mean any disrespect if I'm saying it incorrectly. But on behalf of Mr. Gattas is Mr. Paul Reynolds. And I'm a little confused about who's representing Mr. Smith and Ortho Atlanta. Are they represented by same counsel?
they are not,
Yes.
Your Honor. I'm sorry, they're not represented by same counsel as Dr. Goddess. I'm sorry, I didn't mean to step on your toes.
Oh, I thought you meant were Smith and Ortho represented by the same counsel. And yes, we, Salida Griffin and Brandon Sarton on behalf of both of those.
And
Okay.
Michelle Solandi is with me, Your Honor.
Okay, I do have Ms. Saletti checked off here. And Ms. Griffin and Mr. Sarton are representing Mr. Smith and Ortho Atlanta.
Mhm.
Did I miss anyone? All righty. All right, so I guess we'll address the first issue. Yesterday, I had my staff attorney send an email to you all informing you that I have been, or still am, a patient of Ortho Atlanta, which I had known as Piedmont Orthopedics. And it was only yesterday when I realized for the first time that this was the same company. I don't know if the lawsuit was filed before the name change happened, or I'm not really sure how the companies are organized. But as soon as that looked familiar to me from my recent appointment there. And I said, let me just Google this and make sure that this is not my same office. And then indeed it was. I sincerely apologize for not letting you all know anything about that earlier. It just appears this case hasn't come before me for very much other than signing consent scheduling orders. maybe we had a status conference on it at the time. I really can't remember that well, but I just wanted to explain to you why this came to my attention at such a late time, a week before trial. So I don't know if anyone has issue with that or how anyone wants to proceed, but I thought we would address that before we dive into the issues with motions and limines and other matters.
Well, Your Honor, I assume you did not have any treatment or involvement with either of the physicians named in the complaint?
Dr. Smith and Dr. Gaddis?
Yes, Your
No.
Honor.
No.
Okay. And does the court feel like it has any leaning toward the defendants due to your care and treatment by them?
Absolutely not. And you know, that's the thing. I was joking with my legal assistant yesterday. I said, you know, for me, I'd rule against my mother if she wasn't right. So I just that's just not the kind of judge that I am. So no, there's no leanings for me whatsoever.
And I don't want to get into your health history, but I'm assuming they didn't save your life in some miraculous way.
No, and I don't mind at all. I'm telling you, I was treated for bone spur on my elbow, and I have SI joint pain in my back, and so those were the ailments that I was being treated for. As I understand it, Dr. Smith had maybe he specializes in shoulders. So far so good. I haven't had any issues with my shoulders. I hope they hold up on me.
Okay, I don't think the plaintiff has any problem with it, Your Honor.
The defense, Dr. Schmidt and ortho does not have any problem with it either.
Okay.
And same from Dr. Gaddis.
Okay. All right, very well. We'll proceed on then. All right, so we'll start with Mr. Plaintiff's first motion in limines.
Yes, Your Honor. Do you want us to make just a real short argument on each one, or how would you like us to proceed?
So,
Just to let the court know, we've met, we did confer with what we can agree on, and Mr. Register and I have sent emails back and forth confirming where we are. So we know he can say what we've agreed on and he'll know the answer to that.
Yes, there's several of these that we don't have to discuss, but the first one is not one of those.
okay.
And Your Honor, the essence of this is a tendency by defense counsel in other actions, not these attorneys, but we've heard it many times where they try to raise that burden of proof. Almost it's similar to the motion in limine they file where they claim we try to say things like guilty and stuff like that. We don't want the defense to try to urge the jury to apply a higher standard than what the law allows. And I assume this is probably one that's going to have to come on a case-by-case basis, but we wanted to bring it to the court's attention.
Do you want us to respond, Your Honor? Do you want to ask questions to both sides? How would you like us to handle it?
I'm sorry, I'm having a hard time hearing you, Mr. Reynolds.
I'm sorry, we just got a new office and I'm not exactly sure where to be talking. So is that better at all?
That's a little better for me. Ms. Holloway, are you able to hear him okay?
Yes, I am.
Okay.
And you might can go into your audio
I'm
settings.
doing it right now. Is that better now, Your Honor?
Yes.
All right, I just
Yes.
turned my input volume up as high as it would go.
Okay.
So would you like us to respond or do you want to ask questions, Your Honor? How would you like us to handle it?
I'll hear your response.
I think it's an improper limitation on cross-examination, Your Honor. Whether an expert thinks something else may be possible, we can test the reliability of their opinion. I mean, it is common to ask a juror, provider, you know, how comfortable are you with this? What is your belief on it? It's cross-examination. There's a thorough and sifting cross-examination allowed. Zoran v. Thompson doesn't stand at all for the proposition that we're not allowed to cross-examine adverse experts with regard to this. Zoran stands for the proposition that plaintiff has the burden of proving their case to a reasonable degree of medical probability.
What stands for that? Are you talking about the Zarin case? The
Yeah, the case
ZW?
that plaintiff cited in their motion, Your Honor.
Okay, I just want to be sure that's what you were saying.
Yes, Your Honor, I apologize. I've always pronounced it Zorin.
Okay, that's
I
probably it.
apologize. It may be wrong. It may be what I was taught, and it may be Thompson is the easier way to deal with it.
Okay. I want to deny plaintiff's motion limit number one, specifically as I understand it, when it's an expert witness. To me, an is it possible question tends to ask, I don't know, usually it kind of leans into speculation, but questions of that nature can be asked of an expert witness. I will say this. If it comes to a point where the plaintiff would like, if there's an individual question or something where the plaintiff would like to object to that and have and kind of determine what it is that's being asked there, we'll examine it a little closer at trial. But I'm not going to say that they cannot ask any questions that may start with, is it possible? Or that those questions are not permitted. So I guess one is denied, but we may revisit it as necessary. Okay. I guess I'll just go down these, and if there are any that you don't agree to, then we need to have discussion, let me know. So
Yes, Your
plaintiff's
Honor.
number two.
That, there's no agreement as to that one, Your Honor, and I think it goes to the efforts by defense counsel to try to preload this jury, and throughout trial that the jury's supposed to presume that the doctor complied with the standard of care, and that's not how that portion of the law applies. We haven't, as the plaintiff, we have to prove our case, but they don't get a presumption for throughout the entire trial.
Okay.
I mean, I completely disagree with that, Your Honor. What the court will instruct the jury, I believe, and every medical malpractice case I've ever tried, there is an instruction that is given that there is the presumption that the care is reasonable care. That can be overcome with expert testimony, but a jury is also instructed that they do not have to believe an expert. If the jury doesn't believe the expert, they can go with the presumption. There is no requirement that we put up any evidence. We still have the presumption. The Killingsworth case that's cited by plaintiff's counsel also doesn't stand for the proposition that it is inappropriate to argue that there is no presumption of due care. Killingsworth is talking about in some cases the negligence is so obvious that there is no requirement for an expert, such as if there were a wrong site surgery, you don't necessarily need to have an expert, but there is still a presumption of due care. At the end of this is also a constitutional argument that the presumption is wrong. I don't agree with that. I mean, it is statutory under Georgia law that there is a presumption of due care. And so we disagree with the motion. We think the court will instruct on it. For us not to be able to argue it, I think would be error.
Your Honor, just briefly, he said in the first motion that my citation didn't cite what we said. We cited Zwerin for the proposition that the standard of proof is preponderance of the evidence by it must be proven to a degree of medical probability. That's what Zwerin said. And the Killingsworth case does talk about the presumption of due care and when it doesn't apply. I just think it's improper for the defense to constantly imply to the jury that they are to presume the doctor complied with the standard of care once we have overcome that burden through expert testimony that they did not comply with.
I think the presumption that the court will instruct the jury, I think, is that there is a presumption of due care. And I believe that's the law.
I'm
And
trying to
happy
find that. It's been a very long time since I have tried a medical malpractice case. So give me 1 second to look at this.
I think it's in the pattern.
Yeah, that's what I'm looking at.
At essence, Your Honor, we believe it's an evidentiary threshold, which we have met by expert testimony.
But wouldn't it be up to the jury to determine if they believe you're expert?
They do, and that's where they get the instructions at the end. But to have counsel continually imply that the jury is to set aside that analysis and just to presume the doctor has always complied with it, to me, is improper.
Okay. So I'm looking at the pattern instruction for civil 62.305. And in that instruction, it says the presumption in such cases is that the services were performed in an ordinarily skillful manner. The person claiming an injury may overcome this legal presumption by introducing evidence that the physician did not treat the patient in an ordinarily skillful manner. Okay, expert testimony is usually required to overcome the presumption, and the burden is on the one claiming injury to show lack of due care and skill by preponderance of the evidence. So I'm going to, and essentially what you're asking me to do, Mr. Register, is you want me to prevent the defense from arguing that you did not meet your burden?
Well, I don't want them to imply that the court's going to tell you that Dr. Gaddis complied with the standard of care. The court's going to tell you to presume he did. That's not what the instruction says. It's an evidentiary burden, a threshold that the plaintiff has to overcome. And for them to try to take on the judge's power on their side and insinuate that you have already made a determination that they complied with due care and now plaintiff's got to overcome that, I think creates a hurdle that we're not required to get over with the judge instructing them, or the defense attorneys implying that the judge is going to instruct you that the defendants complied with the standard of care, or that they that they were in compliance, that there's a presumption of due care. Does that make sense?
There is a presumption, though. I'm sorry. Based on the law, there is a presumption, and so I will allow them to argue that, and obviously, that is up for the jury to determine that. I'm going to deny plaintiff's number 2.
Your Honor, I understand and we accept your ruling. I just want to also ask that if they're making that argument, we're able to tell the jury that the plaintiff, under the law, the plaintiff is allowed to overcome that presumption through the presentation of expert testimony that the defendants failed to comply with the standard of care.
Absolutely. I'm sorry.
We would
Go
not
ahead, Mr.
object
Jones.
to that argument at all. I mean, that's
Yeah, I expect you to be able to argue that. Yes, that is permissible, what you just said. All right, number 3.
With regard to 3, we're not going to go crazy with it, Your Honor, but I mean, this is like if a witness is up there and they're testifying, I'm sorry what you went through, or I'm sorry you're going through this. There's not I see this regularly in medical malpractice cases, and it's an attempt to dehumanize us, to argue, it's terrible what they're going through, and someone died, and we appreciate someone died, and we can say that under the law. There's nothing under the law that prevents us from saying that. I agree that we can't go crazy with it, and we're not going to cross a line, but.
You're replying to number 3, Paul?
Yes.
Yeah, well, there's a statute right on point, Your Honor. OCGA 24-444-16.
If a doctor or a hospital in the provision of care were to apologize such that it indicates negligence, that is not admissible in litigation, is what the statute is talking about. There is not an evidentiary rule or any statute that says a lawyer in litigation cannot say that, we're sorry what they went through. it's a completely different situation. It's not, it doesn't fall under the apology statute.
Your Honor, if they're saying it, they're essentially saying on behalf of their client.
Okay. I'm
And I
going
don't mean
to,
to talk for Ms. Griffin. I'm sorry, Salita, I don't mean to talk over you.
No, it's fine. We have some of the same objections, so it's fine. I don't want everybody to be talking at once. So if I have something, I'll add.
okay, please do, Ms. Griffin, because I'm again forgetting that this is 3 different lawyers and not
Yeah.
2. Forgive me. I definitely don't want to keep you from making any argument. Okay. So what I was going to say, do you have anything to say about 3?
No, I don't. Mm-mm.
Okay. You know, I will grant 3, but I will if there is a mentioning of an expression, because what I don't want to happen, let me just say this, what I don't want to happen is at the end of this case, an argument that there is any type of implication made that, oh, you know, the defense don't care. They didn't even tell you, they didn't even apologize or whatever about what happened to this lady. And I just think it kind of goes both ways. But jurors may also, I don't want them to get impression that there is no sympathy or regret about the loss of life here either. So it's a fine line. I'm going to grant 3, but I think I will maybe I'll do better by reserving it and to see if it becomes an issue. So like if there are going to be multiple questions about the defense being sorry that this happened, I mean, it should be very brief. And I expect that most seasoned attorneys know how to do this. So I'll reserve it, but you can see where I am leaning on this matter. If you're going to discuss it, get in, say your regrets, and get out. And that way, the plaintiff does not get the impression that the defense are cold and heartless and don't care about what occurred here.
And having tried a number of cases, Your Honor, I don't think there's any way we cross that line, but
I don't think it's going to be an issue. I haven't had that issue in 8 years. Okay, number 4.
Your Honor, I think we have somewhat of an agreement here. Mr. Reynolds had mentioned that if I'll agree to accept damage in excess of,
he says in this motion is talking about that none of the defendants are going to have to pay it because there's insurance. And my response is if he doesn't want to ask it and above what insurance is, I'll agree to that. I mean, I'm not going to, it was somewhat tongue in cheek, Rob. And I'm not going to talk about in this trial who's going to pay any of this stuff.
well, I think more, I know he's not going to talk about insurance, but I don't want the defense counsel to get into implying that any verdict is going to somehow have a financial impact on or ruin the business or keep the doctors from practicing. They're making the same arguments about some of the stuff that they don't want us to say, and it just shouldn't go there.
I mean, I'm not going to make an argument that it's going to ruin the practice or they can't, but I may argue that it's a serious issue to them, that there's a claim against them. And so they're having to defend against this. And part of the implication of that is any award is against them.
Okay. So it sounds like you all agree to this, but if you still require my ruling, I will grant it. But I don't think there should be any argument made that, nor do I think it's going to be made, but just so it's clear, the defense may not argue that this type of any type of verdict of this nature is going to cause financial ruin or something along those terms, or financial consequences for the defense. So I'll grant 4.
Just for the record, Your Honor,
Yes.
where you say no financial consequence, is the court precluding us from saying that the doctors are responsible for any verdict?
No, I don't want to go that far.
And so that's kind of the line. It's such a broad motion. I think we all know where the line is. I would just ask if the plaintiff thinks we go too far, they object.
Ms. Griffin, I'm sorry. Let me let you.
No, I agree with Mr. Reynolds.
Okay. All right.
We didn't include that statement in our motion, Your Honor. That
You
we
did.
didn't
That was
say
something that I said.
Yeah.
Well, the problem is this motion is so broad where we're talking about, we're implying it. And I'm like, I don't,
Okay.
I
So what
agree
I'll
that I
do,
don't, go ahead. I'm sorry. I don't mean to interrupt you.
I'll reserve for that. But again, I don't think we're going to have a lot of issues here. You kind of can see, I don't want that argument being made. What the plaintiff is concerned about in number 4, but I don't think that you all are going to do that. So we'll reserve it if the plaintiff thinks that they're going that way with any particular question, then object at that time.
Your Honor,
Number
number 5. Go ahead,
Yes.
Paul.
Go ahead.
Number 5, I mean, I think it's an improper limitation on argument, Your Honor. I think it depends on what the evidence shows. If nothing comes in about the system, it also depends on what the ask is. And if there's an ask for $1 billion, then the system can't stand that. I don't think that's going to be the ask, but I don't have any idea. It really just depends on what comes in. What that Williams v. Medical Center case said was Williams v. Memorial Medical Center. It said there was no evidence of an impact on the system. Therefore, that argument was inappropriate. It depends on what the evidence is that comes in the case.
Your Honor, these are arguments that some defense counsel try to make to prey upon the jury's fear that somehow their verdict is going to stop the practice of medicine or ruin these doctors. It's just not, it's not admissible.
I mean, I think there's some similar, I mean, I don't think it's preying on any, I won't say that, it's editorialization. I think it depends on what the evidence comes in and shows, Your Honor, that whether it would be appropriate argument or not.
Ms. Griffin, anything else?
No, Your Honor.
Great. I'm going to grant number 5. There should be no argument of that nature. Number 6.
Your Honor,
This Go ahead.
So what we'll do, hang on, to avoid you all kind of talking at the same time. What I'd like to do is to give defense the opportunity to tell me if they are going to object to it or agree, just so it's clear, and state their reasons, and then allow the plaintiff to get final word. And I think that will keep us moving closely. And I'm still waiting on the ones you all agreed to, because we haven't gotten
I hope
to one
we're
yet.
going to get to some of those soon.
Okay.
But not yet.
All right. So for 6, does the defense object?
Yes, Your Honor.
Okay. Ms. Griffin, you object as well?
Yes.
All right, go ahead. I'll hear from you all. I'll hear from you as to your objection.
Your Honor, it is appropriate to argue that the reputation of them is at stake with regard to litigation.
I'm sorry, your mic is going out again on me, Mr. Reynolds.
Sorry,
I'm gonna try to.
I have a tendency to sit back and put my leg up, and I move away from the microphone is the problem. I apologize.
Okay.
It's not an inappropriate argument to argue that this is the reputation of the doctor. Part of that is at stake with regard to this litigation, that's an important litigation to them. It's not inappropriate for me to argue in closing argument that these are good doctors that provided appropriate care. This motion in limine would prevent all of that, which is an improper limitation. It's just way too broad.
Okay. Ms. Griffin, anything else?
No, Your Honor, I join that objection.
All right. All right. Now, Mr. Registrar, I hear from you.
Your Honor, he tries to couch it as that, but it is pretty narrow. What we don't want to happen is for the defendants to spend way too much time talking about all the things that this doctor has done and how good he is and his reputation, so that they prey upon the sympathies of the jury, which that's not an issue here. The doctor's reputation and in the community, or his standing in the community. I've been here for 20 years. I've helped all the families for generations here. That has nothing to do with the issues in the case. And some defense attorneys have been known to try to spend a lot of time on stuff like that is irrelevant and prejudicial.
How long
All
the
right.
doctors have been practicing and where they've been practicing is absolutely relevant to their skill level and their knowledge level. It is 100% relevant.
So what I'm going to do for number 6 is I will reserve ruling, and the plaintiff will object when he believes that the defense has exceeded what they are allowed to say about the doctor's reputation or standing in the community. That is very broad, and that is difficult for me to kind of, rule on that. Okay?
Yes, Your Honor.
Number 7.
I mean, I generally don't disagree with it. I don't think it's so broad though. I don't think it's inappropriate to argue that money's not going to bring someone back. You know, you're still going to, it would be different if I were to argue you shouldn't award any damages because money won't bring someone back. But I assume the plaintiff is going to argue that we can't bring her back. Therefore, money is all we have. I mean, we hear that argument all the time.
I hear it in every
So,
case.
I mean, it's
Every
an
civil case.
improper limitation on argument, I think. I don't imagine that I'm going to say money will not undo damages, but I may argue that money's not going to bring her back. And so let's talk about what a reasonable value is in this case. It's an inappropriate limitation on argument.
Anything further, Ms. Griffin?
No,
From
Your
defense?
Honor.
All right, Mr. Register.
Your Honor, that's entirely improper. It is urging the jury to not follow the law. Whereas we may say that this is the only way to compensate the plaintiff for the loss and for the full value of the life of this. That follows the law. For them to tell the jury, giving these folks money isn't going to bring her back, that's encouraging the jury not to follow the law, and that's improper.
It's not. It is an argument with regard to what's the reasonableness of a verdict. Part of what we have to do is argue what is a reasonable number. I mean, under the new law, they're required to give their number, and then we have the option to respond.
And I agree they have an option to respond, but not to tell the jury not to give money because she's dead and it won't bring her back. That's asking them to apply a different type of damage to the claims in the case.
I'm sorry, I don't understand that. So if defense argues, just walk me through what you're saying.
Well, Your Honor, if they believe, the only way we get to this portion is if we win on the bifurcation of the initial claim of liability.
Right.
So at that point, we're going to have a very short presentation of evidence, and then there'll be closing. We may have a short opening, a few witnesses, and then closing. But if in their closing, they are telling the jury, you've already found us liable, but by giving the plaintiff money, that's not going to bring her back. They're implying to the jury they should not follow the law and compensate the plaintiff for the loss that they found was already the responsibility of the defendants through the liability portion. And it's not an appropriate argument to make to instruct the jury not to follow the law as to damages.
I'm going to deny number 7. First, if they want to take the risk in front of a Clayton County jury to say that, then, that's on them. But I don't think that argument is asking them not to follow the law, because the jury still has the ability to award damages or not award damages. Just because they find liability, they may say 0 damages. I think that's unlikely, but that is still within the realm of possibility. So I don't think that is an improper argument. So I will deny number 7.
Your Honor, I think we agree on number 8.
We agree with 8.
Yay. Okay. Number 9.
I don't think it's relevant, and I don't think it's going to come out, but I don't think it's proper for a motion in limine. I mean, why someone seeks legal counsel may be relevant. It really just depends on the evidence in the case.
Anything further,
So,
Ms. Griffin?
I
I saw
object
you.
to it. I object to
No.
it, and I don't think it's appropriate, but I don't think it's going to be an issue. But
Okay. I'm sorry, Ms.
Agreed.
Griffin. Anything? All right. Mr. Register.
Well, I don't think they should get into asking the plaintiffs why. or when they sought representation. All they do that for is to try to imply that these are litigious people who are seeking money, you know, and everybody has a right to hire counsel when or how they choose. I don't think that's relevant to the issues in the case.
It may be relevant if it's not to say that someone is litigious or that that they're doing something. I mean, the reason you may do it is to say, well, why did you do something? You in a car wreck case, a client hasn't gone to the doctor for 2 months, and then they hire a lawyer, and then the following day they go to the doctor. That may be relevant in the litigation. I don't think it's going to come out in this case, but there are situations where when you hire a lawyer may be relevant to the case.
I will, I'm going to reserve my ruling on number 9. I don't think this is one of the cases where that type of questioning is going to be happening, where it's going to happen. So, but in case it does, we'll police it at that time. But 9 will be reserved. But at this point, I cannot see how, for this type of a case, why it's relevant, why the attorney was retained. Number 10.
We object to number 10. The employment status of what the person who is the plaintiff does is relevant. It's relevant for how often they're there to see what they're talking about. It's relevant to potential bias. It's relevant to, I mean, I've never seen a motion in limine to prohibit the defendants from talking to the plaintiff about what they do for a living.
I'm confused. The plaintiff works for the Beasley
Yes.
Allen?
Plaintiff is a plaintiff's lawyer.
Oh, see, I told you all, I just know this case has not come before me. I don't know anything about what's happening here. Okay. I was like, what's this? All right. Now I understand this a little more. All right. Okay, Mr. Reynolds, tell me, why would that be important?
I don't know if it will particularly be important or not, Your Honor, but I mean, it goes to how often he's there. It goes to the manner and nature of testimony. The court is going to instruct the jury as to the manner and nature of testimony. It goes to potential bias as to why he testifies the way that he does. It can be relevant in any number of ways. It is pretty much always relevant what a witness does for a living so that they get background information on the witness so that the jury can assess the believability and reliability of the witness. Pretty much every witness I've ever heard testify is asked, and what do you do for a living? And the reason is because it is relevant for the jury to make an assessment of that individual.
Ms. Griffin, anything further?
Nope, I agree.
Mr. Registrar, I'll hear from you.
Your Honor, if they ask him, they're only doing it to try to imply things nefariously about him being a plaintiff's attorney or working for the plaintiff's firm that we're with. It has no relevance to the issues in the case. In fact, as an example, I've tried cases with an attorney whose name is Larry Schlachter, who was the former head of neurosurgery at Wellstar before he retired and became an attorney. And they move in depth to make sure we don't tell the jury that he's a doctor. And similarly here, it has no merit. They can ask him if he's an attorney. They can even ask him what kind of attorney. But for them to try to parade out that he works at our law firm has no bearing on the case. He's not going to have any bias toward his testimony because he works for us. I have no problem with them asking about what he does and who he is, but I don't think they should let the jury know he works for us. That's going to make people go, wait, how does that work?
Mm-hmm. I agree. I'm going to grant number 10, but the defense may ask the plaintiff about his occupation, but there's to be no testimony regarding his employment with Beasley Allen. I just find that even if it is relevant, who employs him, that can turn to be prejudicial very quickly. So,
And we're going to step to number 10, to the ruling on 10, Your Honor.
all right, noted for the record.
And Your Honor, when you say we can ask him what type of work he does, do you mean like, are we limited to just that he's an attorney, or can we go into what type of plaintiff's work that he does?
Well, if I think what was presented to me, and I do agree with, is that witnesses, what they do for a living can sometimes help establish their credibility or lack thereof. But so in this particular instance, I don't have an issue with him testifying about him being an attorney or even, as they say, a plaintiff's lawyer. I don't know how that's really relevant. Um, the plaintiff's lawyer kind of thing. I don't know him working for a plaintiff's firm, how that's really relevant, but I will allow at least that much. But I don't think that any type of testimony regarding his employment specifically with Beasley Island is appropriate.
And I will tell the court for the record, Mr. Register knows this. I was a plaintiff's lawyer, so I'm not disparaging plaintiff's lawyers, but go ahead.
No, I don't think at
Rob
all
knows
that he
Rob and
means
I
that.
used to work together. So, and you can see him smiling there as I say it even. All
All
right.
right.
We agree with number 11, Your Honor. We're not going to talk about their fee agreement.
Okay. Well,
Number 12, we disagree with, Your Honor. It's a wrongful death case. It's the value of the life to the decedent at the time of death. Any pre-existing condition she has is absolutely relevant to what that value is.
anything further, Ms. Griffin, from you on that?
Or Your Honor?
All right, Mr. Registrar, I hear from you.
Well, Your Honor, I guess to the extent that they intend to try to imply are you saying you're going to use it to say she had a shorter lifespan, Paul?
No, I'm saying it is not appropriate to limit someone's medical condition when you're asking for the value of the life to the decedent. I mean,
Well, I
we
just
can
think,
go into their medical history. That's
Your Honor, I think it's irrelevant if they go into years and years of prior medical stuff, which they have no expert testimony in this case as to how that may or may not have affected her lifespan. So what they may try to do is just go into her primary care records and go through all the times that she had a cold or when her blood pressure was high, but they don't have any expert testimony to tie that to her lifespan. So it's just going to be them trying to point out to the jury any aspects of her life prior to this incident where she may have been unhealthy.
her life prior to this incident is relevant when you're asking for the value of the life to the decedent at the time of death. Her medical history is absolutely relevant to what that value is.
But wouldn't that be toward damages, which you guys are moving for us not to talk about until the second phase of the trial?
I don't believe that I will sit there for a long time and go into any of it. I don't assume that you will have any, unless your experts were to talk about life expectancy or something. I don't think that we will theoretically go into it, but I thought the motion in limine covered the whole trial. I mean, I'm not, once we get into the portion of the case that is to the value, I think we can argue what her underlying medical condition is because it is relevant, and whatever the records show that are in, because it is relevant to the value of the life of the decedent at the time of death.
Your Honor, if to the extent that they are moving or that they are intending to talk about her prior medical history in the liability phase, I would absolutely argue that's irrelevant.
Unless there's some relevance with regard to why she suffered the condition she did at this point, I don't necessarily disagree, Your Honor. But again, I mean, I think the motion in limine is too broad as the way it's said. I mean, but I don't believe there should be a motion in limine granted for the whole trial, absolutely, because it's relevant to the value of the life. To the extent I can tie it together with his experts, I may do that. I don't intend to sit there with his experts and go, did you see when she had a cold in 2015? Did you see when I mean, there's no way.
Okay, give me one moment. I'm just trying to memorialize what I am going to rule on this. Okay. So I'm going to deny 12, but there should, I will allow testimony regarding her medical conditions that may be admissible during the damages phase. I don't necessarily think that it is admissible during the liability phase. But I want them to be able to argue, because I think it may be relevant. Um, I'm just giving a worst case scenario. If somebody was, you know, comatose, and that's probably a really bad scenario, but but things of that nature. Um, if she's comatose as a result of other issues that are going on with her, that is a little bit different than somebody who's walking around healthy and then all of a sudden they get sick or they're mistreated for this particular, in this particular way that's alleged in this case, and the injury results. So I think that it is relevant testimony, but it is relevant for the damages phase. I will not allow any mention of previously filed claims or lawsuits for the whole case. That's the last sentence of the motion. You all didn't really say anything about that, but I can't think of a reason why that would be relevant in the case. And a lot of reasons why it should be, why it would
Yeah, I
be
don't think
very
that's going to
prejudicial.
come up in this case, Your Honor, but
Okay.
I don't either. And I think it would be relevant to say, you were in a car wreck 2 years ago, but I don't think it would be relevant to say you filed a lawsuit because you were in a car wreck 2 years ago. I don't think the lawsuit is relevant at all,
Correct.
unless
That's
there's some kind of offset, which it's not an issue here.
And we don't have that here. Okay. All right. So, all right, 13.
I sort of object to it, Your Honor. I don't intend to argue that she assumed the risk of anything, but it really depends on what the evidence shows. I mean, I could see a consent form coming out and I could see some argument that I am somehow arguing that she assumed the risk because there's a consent form, and I'm not going to argue ever she assumed the risk of dying. It's not going to come out of my mouth, but just this is so broad. I don't agree with it, that it's just too broad for me. But I'm not going to argue that she assumed the risk of dying.
Miss Griffin.
And I agree with Mr. Reynolds. I think it's very broad, and I really don't know exactly what they're talking about when they say assume the risk of what. I don't plan to argue either that she assumed the risk of anything, but they say here actual knowledge of the specific danger, understanding and appreciation of the risk of associated with such danger, and voluntarily exposing herself to those risks. When this is a case about blood clot formation, and she's instructed when she leaves the hospital what to do to prevent those. So I just didn't want for that to overlap into that issue of us arguing about whether or not she followed her doctor's instructions.
Mr. Register?
yeah, I don't think we mentioned following doctor's instructions or anything like that. I just don't think they can make the argument that Tyrion Walker assumed the risk of what happened to her in this case.
Okay. I'm going to grant 13, but at this point, I am not equating any type of. Why is my phone ringing? It never rings. I'm not going to. I'm not interpreting any type of failure to follow doctor instructions or anything of that nature being equating to assuming any risk. So if there is any further, if the defense believes that they're entitled to ask a question that may violate this motion in limine, then let's take it up beforehand, and so we can get clarity on it. But for now, I will grant number 13, and I will not allow any arguments of assumption of the risk. 14.
And 14, Your Honor, we object to it. We think it's an improper limitation on argument. I don't necessarily believe I'm going to argue because they're not from Georgia, they're less credible, but it really just depends on how the expert testifies, what they say. I think it's an improper limitation that you cannot comment on an expert.
Mhm. Ms. Griffin, anything further?
No, Your Honor.
Mr. Register?
Your Honor, the statute in Georgia only says they needed to be licensed, and Georgia courts have said there is a national standard, not a local standard. And so to imply that, well, you're from South Carolina, you hicks over there don't know as much as our Georgia doctors do. Not that they would say it like that, but that's what they're going to, they're going to say, well, he's from South Carolina. We do it different here. And that's just not allowed, I don't think, to try to undermine the expert's expertise.
I think to say that they have I think that is a specific argument that Rob is saying that if we tried to argue this, that would be an inappropriate way to argue it. And I think the proper response to that would be to object to that argument. That doesn't make the fact that someone is from another place that may be relevant to argument should be prohibited without knowing what the argument would even be. And that's Mr. Register's assumption as to what he has seen other people are. And I think the appropriate response to that would be to object to it. There is a potential relevance to where experts are from.
Well, I'm not saying they can't obviously ask him, where do you live? Where do you work? That's not a secret. It's just trying to argue that being from there is somehow not the same standard as they do it in Georgia.
I wouldn't argue it's not the same standard, but we may talk about reliability. We may talk about where they're from in argument. I have no intention to argue that there is a non-national standard of care.
Hang on. Say that last part again.
I agree with Mr. Register. It is a national standard of care, but you can talk about where an expert is from. I mean, you can talk about their credibility based on any number of reasons. And a jury can use anything they want to assess the credibility of witnesses. So it's a different question with credibility as opposed to what the standard is, and where they're from may be relevant to their credibility.
But they may, Your Honor, one of the classic things they try to say is, well, why didn't the plaintiff get somebody from Georgia to come testify?
Yeah.
And I don't think that's appropriate.
There is zero law. I'm sorry.
I'm sorry. I made my ruling on this. For 14, I'm going to grant. There shouldn't be any argument made that because a physician or expert is from I say physician, but an expert, that because they're from a different state or any type of, a rural location versus an urban location. I think there's specifically a jury charge that says that the jury can't base their decision on anything of that nature. And so I will grant number 14. If there is argument to be made regarding why the expert is not credible, it should not be one based upon where he's located in the country.
So just for the record, that would prevent plaintiff's counsel from arguing the merits of any educational institution where an expert is practicing, correct?
I think that's
so if it were like a rural or a formal, so they can't argue, Harvard is such a great medical institution, or these are great medical institutions, therefore these are really good doctors. That would prohibit that kind of argument, correct?
Well, that's not the motion that's in front of me.
I thought that's what I'm sorry. I thought that was, I don't mean to interrupt you. I apologize.
That's a different issue, Paul.
It's the same issue. What I heard the court say is that we can't argue this is a rural or an urban doctor, or this is a more reliable or less reliable. And so would that prohibit some kind of argument as to where the providers practice?
I think there you're going into their education or having more education or more prestigious education than another institution. I think that is a different issue than where someone is domiciled. So if you want to make that motion when we go through yours, I will, I'll be able to consider it, but that's not at all what I was thinking about when I'm granting this particular motion, because it doesn't refer to schools or education.
Okay. We
Okay.
accept it, Your Honor.
All right. 15,
We don't disagree.
Ms. Griffin.
No disagreement.
All right, so 15 is agreed upon. 16,
16, I generally agree with it. There's sometimes disagreement about if something's disclosed or not. I don't think it'll be an issue here, but we have no intention of having new or undisclosed expert opinions come forward. I assume Mr. Register has the same feel on that.
Right. I don't think there's going to be any new standard of care opinions.
Ms. Griffin.
Same.
All right, 16 is agreed upon by all. 17,
No objection.
No
Ms.
objection.
Griffin. 17 is agreed upon. 18,
Disagree with 18, Your Honor.
all right.
9.1 affidavits or sworn affidavits by these witnesses. They can be cross-examined with their sworn statements in this case.
Ms. Griffin, anything further on that argument?
No.
Mr. Registrar, I hear from you.
Well, Your Honor, 911 9.1 is a gatekeeping procedural requirement. And it specifically says in the statute, and the affidavits that my experts sign reference the statute, which says it does not require the disclosure of all opinions. The statute says you only have to assert one specific departure from the standard of care to check the box on the gatekeeping procedural requirements. What they do is they bring out the affidavit, which is made early before the case is even filed, before discovery is done, and they say, you didn't talk about it here, so you must not have thought it. You don't really believe that. And to me, that's an improper usage of the affidavit to try to impeach the credibility of the expert based upon a procedural document that we have to file.
It is absolutely relevant to the expert's opinion. It is an absolutely appropriate cross-examination. If counsel wants to have an expert explain why they have different opinions than were in the affidavit, that is absolutely something that he can do. But it wouldn't make it inappropriate to cross-examine them with regard to a sworn statement in this case. It is absolutely relevant. There is no basis to exclude cross-examination on it.
And I think it's misleading and it's a misuse of the affidavit for what it's intended. And to the extent our motion is really only to that issue. I mean, if they want to go through the facts in the affidavit or the one opinion that he may have expressed, but not to try to say he didn't have those, he didn't have to have them in that affidavit.
Whether he has to have them or not is a litigation tactic. An expert can be cross-examined about what they put in the affidavit all the time. While counsel may have written that affidavit for the expert, that theoretically would be relevant too. As to the reliability of this expert, their bias, whether the jury should believe or disregard their testimony. All of it is relevant.
Okay, I'm going to deny number 18. I do find that a witness may be cross-examined as to what is contained within their 911 9.1 affidavit. And of course, the witness may explain their reasons why certain opinions are not present there. I will say that the more questioning on that it's going to possibly open up I don't want to get into matters, pre-litigation matters that don't necessarily involve the jury, or the jury shouldn't necessarily know about. For instance, the circumstances of how the affidavit was drawn up. I don't know. I think that So I'm denying 18, but if we gonna get into that type of cross-examination, if there are going to be any issues regarding that type of cross-examination, then we may need to kind of identify and limit further um, how far we're going to go. I don't want there to be, and I'll just tell you what I'm thinking. I don't want there to get, to get to the point where we're having to talk about attorney work product or, um, in this particular case, because the attorney is employed with the plaintiff's firm, attorney-client privilege. I mean, maybe I'm thinking further than what it requires. But when Mr. Reynolds just mentioned about the circumstances of how the affidavit was, I guess, drawn up, that's what I started thinking about. I mean, again, perhaps I just don't know enough about that since I never practiced medical malpractice law to know what could be an issue and what could not be an issue.
I think that's totally irrelevant to the case, how the affidavit came about. We're not trying the affidavit, Your Honor. We're trying the issues in the case. They just bring this stuff up to try to make a mess and try to make it sound like the expert wasn't paying attention early in the case and didn't think about all his opinions and didn't have it then. But we don't have to do that. That just gets us through the doors of the courthouse.
It is relevant to the expert's opinion, the reliability of the expert. That's why it is a sworn statement that the expert has given in litigation. It is absolutely relevant to this litigation. It is an appropriate measure for cross-examination. I won't get into, if the court doesn't want me to, who drafted the affidavit, or I will at least approach the court and say, I'm going to get into this now before I do it so that we can talk about it.
Okay. Give me one moment, please.
Thank you.
My apologies. Okay, so I've denied 18, but we may have to have some further discussion about it if things come up at trial about that one. Okay,
Okay.
19.
You know, just for the record, Your Honor, the motion was as to commenting on why the expert didn't have additional allegations or opinions. That was the extent of this motion in limine, but that's
Okay.
denied.
Yes, that's denied. I think that the expert can I think it's relevant as to why he did not have that. And I also think that he should be able to explain at that point why he did not. And that in that explanation is what I'm concerned about, because I don't know how the decision was made. But certainly I think if they are, I'm going to permit them to ask about that, then certainly you have the right to have the witness explain why that came up the way that it did.
Okay, thank you.
Okay. 19.
Excuse me, Your Honor.
Yes.
I was just checking how many more do we have?
Well, we haven't even finished the plaintiffs yet.
Okay,
Do you need a break, Ms. Court Reporter?
yes.
Okay, we can take
Thank
a,
you.
you need 10 minutes, 15,
7
7.
minutes. Yes, thank
I'm
you.
on. Okay, so it's 2:38. If we could be back at 2:45.
All right, thanks.
Thank you.
Back.
Bye.
All right. We're waiting on a couple of more folks to come back in.
Like your background.
My background or somebody else that has a nicer
No,
background?
yours. It looks like you have the courthouse and everything in your background.
Yeah, that's magic.
Bob's always got Beasley Island. I just have a nondescript office. All right. You ready, Rob?
I was waiting for Miss Griffin to come back and Mr. Sarton.
And we'll try to move quicker, Your Honor. Sorry it's taking so long.
I brought my patients today.
Thank you.
Your Honor, Ms. Griffin had to step away for a moment. I'm going to jump in her for play if that's okay with the court.
That's fine with me. That's fine.
Great.
Yeah, Mr. Yeah, registry. Like I said, I have this case is not. You all must have gotten along very well in this litigation because I haven't seen you. Like there's been hardly anything, and I love that. Thank you so much. Okay, from the bottom of my heart, because there are some folks I see every other month. Okay. 19.
Yeah, do we, Madam Court Reporter, are you back? Are you good?
Yes, I'm back.
Sorry about that. Your Honor, I generally don't disagree with this. The only question to me is what the evidence is that plaintiff's going to put in. There's been some indication that the plaintiff has said that he felt, that they were ignoring him and ignoring that, not, I'm paraphrasing, but not treating her well and ignoring her and wanted to get her out. And so if testimony comes in that, they didn't care about her and they weren't doing anything, then we need to be able to respond to that. And so I object to the motion because I think it depends on what the evidence that comes out in the plaintiff's case is and whether or not I can go into this.
Okay. Mr. Sarton, anything further?
We join the objection, Your Honor.
Okay. All right, Mr. Registrar, I hear from you.
Your Honor, it's generally a motion to preclude the doctors from getting up there and talking about how much they love Miss Walker and love this family to try to invoke sympathy. If the testimony is in direct response to some allegation, that may be different. But for them to come up there and just try to invoke sympathy because of them being a loving, caring person and didn't mean for this to happen type thing, I think that's irrelevant.
Great. I'm going to reserve my ruling on 19 to see if that becomes an issue. Okay. 19, I'm sorry, 20.
I don't disagree that we can't talk about negotiations or statements made in compromise. I don't disagree with that. I don't think it's inappropriate, though, to say the reason we're here is because people aren't being reasonable. If there's a demand, again, if someone were to say we're asking you to award $1 trillion, but I think the door would have to be open. I don't think any of that kind of settlement communication is relevant or admissible in any way.
Mr. Sarton.
We agree, Your Honor.
All right, Mr. Registrar.
I think he's saying he agrees with it because I believe they filed a similar motion, but
Okay.
basically this is any reference to the parties' settlements or whether or not any party was acting reasonable in their negotiation of settlements. Now, but that's different from responsibility.
Okay.
See, so that's the problem right there. Okay. If the plaintiff were to say defendants refuse to take responsibility in this case, then can I make a response that we have made a 7-figure offer already in this case to try to take responsibility that the plaintiffs have denied? I don't think I would be allowed to make that argument, but I've got to be able to respond that I'm not taking responsibility. So that would be an absolutely inappropriate argument.
Okay.
Your Honor, that's totally different.
Hang on. All right. Go ahead, Mr. Registrar. What were you saying? Because I get Mr. Reynolds' point.
Well, this motion is as to the conducts or statements made in negotiations at trial, settlement negotiations, what has been or has not been offered or accepted. But when it comes to responsibility, that's That's the doctor accepting fault or responsibility for causing an injury to this patient. That is his, whether or not he is accepting the fact that he was negligent. The fact that his insurance company might want to make a small settlement offer, that's totally irrelevant as to the issues of whether the jury's going to want to know, Dr. Gaddis, Dr. Schmidt, do you accept responsibility for causing this patient's death? And they're going to say, no, I don't.
Which would be an absolutely inappropriate question to ask. Because the question with regard to responsibility, do I then get to respond, was, yeah, we consented to settle the case, and this is the offer that's been made that was a 7-figure offer. The question, and the only issue in this case, as Mr. Register has shown previously in his motions, is was there a violation of the standard of care that caused injury? So an appropriate question would be, doctor, do you believe that you violated the standard of care?
Mhm.
Not, do you believe you're responsible? The question is, do you believe you violated the standard of care? Because that's what's at issue. Not, do you accept responsibility for it? Not, is it your fault? Did you violate the standard of care?
Fault, the word fault is actually in the apportionment statute.
Apportionment is not an issue in this case, I don't believe. I don't believe there's been a notice of non-party fault filed, unless I just don't know about it.
No, there's apportionment between the two defendants.
There is, but the question in the litigation is, was there a violation of the standard of care? So that would be the only thing that could be asked, especially in the first phase of trial when there's not any apportionment that's being done.
Your Honor, that I don't want to waste the court's time. That's a totally separate issue than this motion in limine as to settlement negotiation and reasonableness of the parties.
Well, if he were to ask whether we would take responsibility, I think that we would then be able to get into settlement conversation and that we have made a substantial 7-figure offer.
That's
All right.
that's never been a part of any type of responsibility argument ever.
Okay. So for number 20, I'm going to grant there should be no evidence or reference to conduct or settlements made in compromise negotiations. Should be no evidence of that presented at trial. I will also say that it's not a proper question about taking responsibility. I will allow the defense to object to that question, but I don't know if it's in any of their motion in limines. But, you know, I tend to agree with Mr. Reynolds that now that this matter is going to trial, it is up to the jury to determine if there was a violation of the standard of care, and if there was, to the extent, how much, if any, of the damages are attributable to the respective defendants. And so responsibility, that's very broad, and I just don't think we need to go down that road. And so there in terms, because at that point, then I think I'm not probably making very good sense, but I tend to agree that can be a slippery slope. And so what Mr. Reynolds has mentioned, I'm concerned about that. It is not fair to say that the defendants have not tried to take responsibility if there have indeed been offers made. I've dealt with cases where there haven't even been offers made to anyone. And so that if that's not the case here, we just need to stay away from that altogether. So I'm going to grant 20, but if plaintiff goes down that road, then I'm going to allow the defense to come back and ask some questions about whether or not they really tried to take responsibility. So
Thank you, Your Honor.
21.
You know, I don't, it's, again, we don't agree. We don't agree that with potential other causes, it'd be like asking a plaintiff's expert. I think this would prohibit me from asking a plaintiff's expert, don't you agree this could have caused it, this could have caused it? If I try to prove what a specific cause is, then I have the burden of proof. But potential alternative theories of causation, I don't have the burden to prove what the cause is. What Zworin talks about is the party that is bringing a medical malpractice claim has to prove the cause to a reasonable degree of medical probability. I don't have to prove potential alternative theories of causation.
Mr. Sarton, any
We agree with
further
that
argument?
objection, Your Honor.
Okay. All right, Mr. Registrar, I hear from you.
Your Honor, if they bring forth at trial some type of alternative cause of Miss Walker's death, I believe they absolutely have the burden of proving that. That hasn't been brought up in this litigation to date, but I have seen stranger things by med mal defendants at trial. But they do have a burden if they're going to try to convince a jury there's an alternative cause of her death. They don't have a causation witness anyway, Your Honor, but I believe they will try to make that argument.
I'm sorry, it's about 2 pages, so I just want to make sure I'm not missing anything. All right, I'm going to grant 21. And let me just say this, I don't, in this particular case, from what I've been made aware, and from what I've already heard, there was some instructions given to the decedent regarding things to do to avoid blood clots. And eventually, I believe she succumbed to a blood clot following one or more of the defendant's care. So if the issue is coming down to the defense claiming that she did not follow those instructions, and that is what caused her death, and not, obviously, I don't think they need to present any. They have the burden of establishing any causation theories as to saying that the decedent did something or did not do something that she should have done. So I'm not sure, but obviously, if the defense is going to say, "Oh, the decedent passed away as a result of," I just don't know any other condition, but I'm just going to say, I'm sorry,
A myocardial infarction, an MI.
I can't hear anything you just said. I'm sorry.
I said a myocardial infarction, an MI. If we were going to say that
Yes.
the cause of death was actually a MI, not a PE.
Then you need to produce evidence to prove that. Thank you for that hypothetical. I hope that was hypothetical, but thank you for that, because I wasn't coming up with anything. And so is that what you are talking about, Mr. Registrar?
As the proximate cause for her injuries, if they believe that some person violated the standard of care, which I haven't heard that in the case, or if they believe there was some other medical cause, such as what Mr. Reynolds just said, they have the burden of proof on that. If they're going to cast aspersions at Ms. Walker, then, I think they can try to do that, although I would dispute the evidence on that. But, I don't know if I can stop them from casting aspersions on her, but that's not causation.
Okay. So I think you all agree. I think we're on the same page. All right, 22.
I mean, this is exactly this. We disagree with this. We object to this, Your Honor. This is basically plaintiff's counsel attempting to tell me that I can't cast aspersions on her. This is an argument trying to say that I can't say that she didn't follow instructions or that she didn't do what she was supposed to do. That's what this motion is, and I don't think it's appropriate.
Anything further, Mr. Sarton?
We agree with that objection, Your Honor.
All right, Mr. Registrar, I hear from you.
Your Honor, this is not a car wreck case where there is allegations that Ms. Walker was negligent. And what they're going to try to do, I think, and that's why they're objecting, is they're going to try to turn it into her being negligent. Now, they can talk about what she did or didn't do if they want to, but they can't get her on the verdict form as having any fault. There has been no testimony to date in this case that she did anything that caused her injury.
She absolutely goes on the verdict form by statute, and it would be simple negligence because they're not professional. Failure to follow medical instruction is simple negligence. I think your experts will agree that if a patient doesn't walk around when they're told to, that can lead to a pulmonary embolism, can lead to a DVT, which can throw and become a pulmonary embolism. A jury could absolutely find that she has some responsibility with regard to that. Whether we will make that argument and go down that road, I can't say, but it's not appropriate to prohibit us from doing so.
It's a medical malpractice action, Your Honor, and they have neither the doctors or their expert have said Ms. Walker did anything to cause her injury, to cause her to develop a DVT. This is just the lawyers trying to make her sound like she didn't. Nobody has said she couldn't ambulate. She had a broken leg and a broken arm, and they knew that. They should have known it.
That's argument is what that is.
So I'm going to deny 22. If there are medical records to show that, which is evidence, to show that the decedent was not ambulating or moving around, and there is testimony that failure to do that can result in blood clots, then I think that is fair evidence that can be presented to this jury. So 22 would be denied. 23.
I think if we want to, I object to 23. I think if we want to put another entity on the verdict form, we would have had to give notice of non-party fault, which was not done. I don't believe. And just to let the court know, I'm only recently in this case, but I'm pretty confident about that. That's why I say I don't believe. I do think, though, it is not inappropriate under Georgia law to argue someone else was responsible for this and we were not responsible at all. That is within the standard, that is allowable. I don't know what the home health providers are going to testify to. They were identified on the pretrial order, but they haven't been previously deposed. I don't know what they're going to testify to. If they were to testify a certain way, it is possible we'd say, this is the responsibility of the home health care. I mean, that's entirely possible, and that would be an appropriate argument. This is not our responsibility. This is on them.
Mr. Sargent, anything else? Okay. All right, Mr. Registrar, hear from you.
Your Honor, those home health people were identified early on. They've had the records. They chose not to depose them. I don't believe they're going to blame anybody else either. But if the defense, there's a statute, if the defense wants to blame or attribute fault to another party, they have to file a notice of non-party fault. None of that has been filed in this case. And on top of that, that gets us back to the same law we discussed earlier, which is if a defendant wants to blame someone else for Miss Walker's injuries, they then assume the burden of proof. They got to have expert testimony that somebody violated the standard of care required of that person. They can't just cast aspersions against folks that they haven't even claimed. And there's been discovery requests. Do you blame anybody else? Do you contend anyone else was at fault? I asked the doctors during in depositions, do you blame anyone else? No. And for them to come to court and just willy-nilly throw out those types of claims is subversive to the law we have in Georgia that sets a framework for doing so.
511233, the statute that talks about, that's if there wants to be apportionment of fault and there wants to be place them on the verdict form. Prior to apportionment, it is relatively common for parties to argue that it is not the fault of anyone named, it's someone else's fault, but you don't apportion. That law was not changed. That is still the law. Whether I can meet my burden with regard to, is this someone else's fault? I don't agree with Mr. Register that depending on how the testimony comes out, we theoretically could argue if you want to blame someone, it was this entity's fault.
Your Honor, that'd be new theories that haven't been brought forth in discovery in 2 years.
There is no obligation under the Civil Practice Act that we disclose attorney strategy, and I don't know what these people are going to testify to.
Why didn't you depose him?
Well, I wasn't in the case, Your Honor, so I can't answer that question. I don't know if there was a belief that there was going to be reliance on the medical records and they wouldn't be called. You know, it is relatively normal in a medical malpractice case for parties to say anyone and everyone who is listed in the medical records may have relevant information. That would include theoretically thousands of people. And so normally it is, who do you intend to call? Mr. Register and I was out of town last week, but the week prior we had a conversation. I asked him, do you have any objection to me going ahead and deposing him now? Just so I know what they're going to say. And I was told, you know, it's too late. I've reached out to their lawyer to see if I can set up a deposition. But so I'm going to try to before the trial. But I don't know if that's going to happen.
All right. Well, at this point, since we don't know, since there's no such evidence that it has been produced that it's anyone else's, a non-party's fault, then I won't allow that. I won't allow any assigning of fault or blame to a non-party at this point. If that changes, then we need to revisit this.
Okay.
So 23 is granted.
24, this is present value is what this is. I mean, I think we're required under, I think the jury is required and instructed under certain circumstances that they need to reduce award to present value. I don't think it's inappropriate to argue that there needs to be a present valuing. I don't intend to argue about what the future value of an award is, but you know, to the extent that there are medical bills, lost wages, any of that, there's a requirement, and I think there's an instruction about present value.
So are you agreeing with this? I guess
I mean, generally accept with regard to present value.
So generally you agree?
Yeah.
Okay.
do
Mr.
you
Sargent?
We join that position, Your Honor.
I'm sorry.
We join that position.
Thank you. Did I cut off somebody?
No, Your Honor.
Go ahead, Mr. Rich.
Well, I think they agree. They're talking about
Okay.
something totally different, which is if there's future damages, we don't have that because we're not alleging future lost income. We're not alleging future medical expenses. There is a component of the wrongful death statute that takes into account the economic loss, but that's part of the full value of the life. And I don't believe that present value applies to that.
Are you
Okay.
arguing for lost wages, lost future wages, Rob?
No, I think what she would have made the remainder of her life is part of the economic component of the wrongful death. But none of that's addressed in this motion in limine. This is preventing them from telling the jury, well, if you only give her X amount now or them X amount, they can invest it and it'll be 20 million in the future. But so that,
I'm not going to say anything like that. And because I don't know how to do the math, but I mean, I may say, you know, you've got to reduce any, I could see saying, you know, under the statute, you're going to be told you've got to reduce future lost wages to present value.
But that's not what this is about. So.
And I just wasn't clear that's what this is about. So that's fine.
Okay. Me neither. So it's agreed. 24 is agreed. Who have you been trying cases against, Mr. Register? My goodness.
I know. Seriously.
Investing? Okay. 25.
Well, I won't bog us down, but they do that a lot. They'll call you up and say, look, we'll offer this to you, and that could be this much in 5 years. And I wouldn't put it past some attorneys to tell the jury that, but we don't know what the stock market's going to do.
25, I don't have, well, but then you also have economists that come in to testify about it. Anyway, whatever. 25, Your Honor, it's an improper limitation on argument. I don't have any intention to argue that this is playing the lottery, but it also depends on what Mr. Register were to ask for. I don't think it's an appropriate motion in limine.
Mr. Sargent.
So I object to it.
We join the objection, Your Honor.
So he's not objecting to it, right?
Oh, well, we
right,
joined,
Mr. Reynolds?
I am objecting to it. I think it's an improper limitation on argument. I don't
It's,
intend to
oh,
make
I
it-
see. Okay, all right, I'm sorry, Mr. Sargent, so you do join his objection.
But just quickly, Your Honor, there's case law on it. They're not supposed to make this formal, respected process of litigation by degrading it and telling the jury it's like gambling or playing the lottery. They're trying to just degrade the system and what we're doing there to try to get compensation, and it's not allowed.
There is zero Georgia authority on this. You have cited some foreign authority on it. There is no Georgia authority on it. No Georgia court has ever agreed with this or said this is the law. I don't know in those cases what exactly was being argued. Again, I believe that there was $1 billion verdict that was issued out of a court in Georgia. And depending on what the ask is, it may be an appropriate response. Again, I don't intend to make it, but it is not an appropriate limitation on argument.
I think this argument before, but I don't know if I was aware that there was no Georgia law on it. I don't recall.
Because most courts grant the motion prior to trial to prevent it.
That is not true. Most
I feel like I've
lawyers
granted
say
it before.
Most lawyers say exactly what I say is they say, I don't think I'm going to argue it, but it's not an inappropriate.
Well, I've always had it granted because it's disrespectful to the court to try to call it that.
I'm going to grant 25. 26.
I mean, I generally agree. We're not going to attack the tort system or plaintiff's lawyers, Your Honor, but this is just too broad for me to understand it. I mean, plaintiff and a chase for money. I mean, I've seen an argument. This is a money grab. I mean, this is too much of a limitation with regard to an argument. I don't understand it. It's too broad.
Mr. Sargent, any further argument or discussion?
Nothing further, Your Honor.
Mr. Register.
It's just like the other one, Your Honor. They're trying to degrade the system and they're trying to bring in tort reform for those jurors that might be, agitated by what they've read in the media. I just don't think it's relevant to the issues of damages.
Yeah, let's keep tort reform out of the case as much as possible. So I will grant 26.
So I'm going to accept the 26, Your Honor. Just for the record, you're telling me I can't argue that that they're making an unreasonable demand and it's a demand to the jury and is a chase for money.
Say that again.
Yeah, what he has here is that I can't say anything about a chase for money. That's one of the statements he has. So for the record,
chase.
I can't. Yeah, chase for money. He says, to attempt or elicit testimony during the entire course of trial, making inflammatory or relevant comments about plaintiff's lawyers, a chase for money, or the tort system needing reform. So if he were to make a $80 million demand to the jury, I can't say this is an inappropriate chase for money. It is not an appropriate amount of money that he's claiming.
I don't want, Mr. Registrar, I don't want to prevent him from saying that. But what I want to prevent you from saying is to get into discussion about, especially given light that this plaintiff is a plaintiff's lawyer, to get into discussions about plaintiff's lawyers being greedy or, they just want money, or this is the reason why we had tort reform in Georgia to stop this type of request. And so that's what I was essentially saying, that a chase for money, I think is a permissible statement. I don't think it impinges on plaintiffs' attorneys or discussing tort reform. So if you're going to limit what you're saying to that, but I know that, there may be other ways that you want to comment on what you view as unreasonable requests for damages. But I would just say, I mean, you can certainly say that they're unreasonable, and I think that you can even say this is a chase for money, but I don't want the argument leaning towards talking about specifically plaintiffs' lawyers in general or tort reform. I just don't think that those things are, well, I think they're prejudicial, and I don't think the jury needs to hear about those things. That's not relevant to what they have to decide. But you can certainly say that that's unreasonable what they're asking for.
I cannot imagine saying anything about tort reform in litigation. I can see asking in jury selection, does anyone have any opinions about tort reform? But outside of that, I can't see asking any question about tort reform in litigation. I think it would be absolutely inappropriate. I don't anticipate making an argument about greedy plaintiffs' lawyers. But that's again why I'm saying this motion is just way too broad the way it's written. There's no way for me to know what the lines are of what I can say and can't. I would ask the court reserve and for counsel to make objection if they believe we've crossed the line. I mean, one of the exact phrases that they have listed, the court has said that's an appropriate thing to argue.
And that may be my mistake, because I was really going off of the title, attacks on the tort system and the plaintiff's lawyers. And, I did read the inside, but I skipped over a chase for money.
And so I would ask the court reserve on this and the counsel make objection if he thinks we're crossing a line.
We weren't trying to sneak that in, Your Honor. It was just part of the description of these arguments that some attorneys try to make about lawyers and greedy plaintiffs and tort reform. But I think we understand your ruling. However you want to either reserve it or grant it, or you could grant it and allow him that phrase if he thinks that's appropriate for him to say. But
that's the problem I have, though, is it says implicitly or explicitly. And so now that phrase that's in there is allowed. Is that the only thing I'm allowed to say, or can I say
No,
something?
it's not. So this is my ruling. I'm going to grant 26. However, the defendant may comment on what they believe to be unreasonable requests for damages. So I'm not going to limit, as long as it doesn't impinge on greedy plaintiffs' attorneys or tort reform. If either party, it's not going to be a situation, Mr. Reynolds, I haven't had a case with you before, but I don't think you're that type of attorney. You're going to make this about the issues and not about anything else. So that's kind of where I'm standing for now. If we need to have further discussion about 26, then we can.
We're fine. I think that's fine. I mean, I'm not going to talk about tort reform or greedy plaintiffs' lawyers.
Okay, and that's my primary point of this ruling. But certainly I do not want to limit your argument regarding what you feel as though the demand is not justified by the evidence. Okay, 27.
I don't understand this argument, Your Honor. So I sent Mr. Register this. It says, however subtle a comment. I mean, you can't argue not to follow the instruction. Mr. Register and I aren't going to necessarily agree what all of the instructions mean. This is just so broad. I don't know what I'm allowed to do or not allowed to do. I don't understand it is really my, any suggestion of jury nullification, however subtle, an argument that I say that a reasonable value should be this, someone could argue that that is an argument to nullify this because a reasonable value is only this.
That's interesting.
It's so broad. I don't understand what it means. Regarding the issues of joint and several liability rule, there's going to be apportionment between the parties in this case. So I don't understand. I just don't understand what this means. I generally know the law and I try to follow the law as much as I can. And I think if Mr. Register thinks I've crossed the line, he'll object. I mean, he and I have known each other a long time. I have no intention of going over the line.
Mr. Sarden, any additional argument?
Nothing further, Your Honor.
All right, Mr. Registrar, I hear from you.
We tried to make it as specific as possible, Your Honor. We just don't want any of these defense counsel trying to bring into the discussion a problem with litigation crisis, insurance, litigation, tort tax. That has been an issue at times in other cases, and we bring that up to alert the court that that's improper. And I do think we know it when we hear it, but we can't put it back in if they start saying it.
So the problem is, to me, the however subtle, and I don't know what this argument is, what this motion is trying to prohibit me from doing.
I'm going to reserve 27. I think I have an idea of what Mr. Registrar is trying to argue. But it is the kind of thing that I don't think we should have a concern with in this case. One, because of, again, our jurors. You're not going to probably win them over talking about this. But certainly, if the issue comes up that the plaintiff feels as though the defense has asked a question or made an argument that would imply jury nullification, then please make that objection at that time so that I can figure out what's going to be the best course of action to allow that question or argument or not. So we'll reserve 27.
28, no objection.
Any objection for you, Mr. Sarden?
No, Your Honor.
28 is agreed upon. 29.
Again, I don't intend to do this, but I think it would be an improper limit on cross-examination too. And it really just depends on how the trial goes, whether or not we would ask the plaintiff, what is he asking for? But I don't see it coming out, but I don't think it's a proper limitation on cross-examination.
Mr. Sarden, anything else?
Nothing further, Your Honor.
I didn't think this one would be an issue, but it's similarly, I can't ask the doctors how much they think the jury should award, and they can't ask the plaintiff, who's the administrator of the estate and the wrongful death claimant, how much he thinks the jury should award. That's the province of the jury after hearing all the evidence, and that shouldn't be asked by anybody on any of the parties.
All right, I will agree with that, and I will grant number 29. 30.
So I've asked for clarification from Mr. Registrar for this. I'm not sure I understand this motion. As I read this motion, he is trying to prohibit any cross-examination or direct testimony from his clients about how they feel about the doctors. Is that correct, Mr. Registrar?
This is 29. Is it, you're talking about 30 or 29?
30.
Oh, you're talking about 30. Sorry. I thought you were.
I think he's talking about 30, right, Mr.
Okay.
Reynolds?
Yes, Your Honor. 29, I said we don't have any problem. Or no, not we don't have any problem. The court gave its ruling on 29. I'm now going to 30.
We're on 30.
I mean, it's testimony regarding plaintiff's personal criticisms or feeling towards the defendants. I mean, so as I read this motion, this prohibits any testimony, direct or cross-examination from the plaintiffs regarding how they feel about how they were treated by the doctors. Am I understanding this motion correctly?
Well, I don't think you would allow me to ask them about whether or not they believe the doctors complied with the standard of care. Now, my folks are able to talk about what happened and how they observed your doctors acting, But as to standard of care type questions or personal feelings about their conduct, I don't think you would want me to ask them that.
He was
I don't.
trying to
That's-
clarify. Hang on. I just want to make sure we're on the same page here. So,
Yeah.
Mr. Reddish, I thought that Mr. Reynolds was trying to clarify what this motion was. I don't think he's taken a position yet as to whether he agrees or does not agree. Is that right, Mr. Reynolds?
That's correct. I mean, there's a statement here, testimony regarding plaintiff's personal criticisms or feelings toward the defendants. I mean, is this motion intending for you to be able not to ask those kind of questions against of your clients? I have no intent to question your clients on whether they believe my clients violated the standard of care. I know the answer to that question.
Yeah, and I'm not asking my clients about the standard of care.
But this motion is broader than that as written. As written, this would prohibit you from asking how they feel about them. And I don't have any objection to that. But if you bring out on direct how they feel and how they were treated and things like that, I need to be able to respond to it. And I'm trying to figure out what is the intent of this motion.
Well, mainly it's for you not to try to embarrass my little old grandmother and the sister of Ken Wilson by asking them to criticize these doctors to make them look bad, because they might get emotional and say bad things. And I just don't think that's appropriate to elicit, they feel terrible about what happened to their mom, but I don't think you can try to make them criticize these doctors.
So I have no intention of asking a lay witness what their opinion is, but it depends on what the questions come out in direct with regard to how we will cross-examine the witnesses, Your Honor. If someone testifies of how they were treated, then I may go into their opinions about things. But
Mr.
I have
Sargent,
no objection.
I'm sorry, I
not
didn't know you
being
weren't
able-
done.
I'm sorry, I have a tendency to stop sometime and then talk on. I have no objection to a limitation of him not being able to ask his client or any other witnesses how they feel they were treated, anything like that.
This is about testimony and not about questions. I guess it's about both questions and testimony. So to me, that's questions on either side from plaintiff or defense about this particular topic. So that's what I'm understanding. So I'm understanding, and I'm going to let Mr. Sargent give me some input here. But as I understand it, because I like things to be concrete, the plaintiff, if the plaintiff asks one of their witnesses, how did the doctors treat Miss, sorry, what's her name? The decedent. I'm sorry, I can't remember her name.
Ms. Walker.
Miss Walker. How did Dr. Gaddis treat Miss Walker when she would go in for her visits? Oh, he was dismissive of her. He didn't listen to what she had to say, and he rushed through the appointments and that sort of thing. And so I'm understanding that question is not to be allowed, or testimony to be allowed as well. If that question and testimony is not to be allowed by the plaintiff, or by the defendant, neither side can get into that.
Your Honor, I think we will withdraw this one because of the confusion, and I guess we can address it when such questions come up, if they do.
Okay.
The 30 is withdrawn.
Withdrawn.
All right, 31. If plaintiffs will agree not to make any argument that that I believe attempts to solicit sympathy for their clients, I will agree not to make any argument that he believes will not attempt to solicit sympathy for my clients. I think we will disagree with regard to what arguments are an attempt to solicit sympathy. Therefore, I think I say this somewhat tongue in cheek to say that this is entirely too broad. I don't think it's an appropriate motion in limine. I think if you think I've crossed the line and I'm asking for sympathy, then I think you make an objection.
Mr. Sargent, anything else?
No, Your Honor, we would just ask that the court reserve and allow plaintiff to object if he finds that we're crossing the line.
Thank you. Mr. Register?
I'll agree to reserve it if the judge would. I will object. I don't think they're going to go too far with that, but I think it's different when the defendants are trying to elicit sympathy versus when you're talking about the decedent's view of her life and her what she lost.
Okay. I will
32,
reserve. I will say sympathy is sympathy. So, but I will reserve that, and we'll rule on it if necessary. 32.
Or 32, I mean, I think argument by definition is personal belief of counsel. I mean, suggestion of counsel by counsel as to their personal beliefs. I mean, I am going to argue that in closing argument that my expert is more reliable than their expert. It's a completely appropriate argument. I'm going to give the basis for why I think the jury should believe that. That is a suggestion of my personal belief. I agree, because of the way that the law has evolved, that it would not be appropriate for me to say, I believe that my expert is more believable than their expert. However, it would be appropriate for me to say, our expert is more believable than their expert, which is a suggestion as to my personal belief. An argument is a suggestion of personal belief by definition.
Not necessarily. But
It may not be the actual personal belief, but it is a suggestion of personal belief.
I got you. Okay. Mr. Sarden, anything else?
Nothing further.
All right, Mr. Register.
Your Honor, I think it's pretty clear. We can't put our personal beliefs out there. We can categorize or characterize what facts have been presented, and we can make arguments as to those facts, but we can't say that I believe she didn't need anticoagulants. I believe that she would have been safe. She was more likely to fall. I think you got to argue the facts and the issues. You can't talk about what you believe.
Okay. That is fair. I will grant that. But if those statements are supported by the evidence, then they will be permissible. But not giving counsel's personal belief. So I will grant the motion in limine, number 32. 33.
Just for clarity, just so I don't cross the line, because I'm going to argue who I did intend to argue who they should believe. The
I'm
court is
sorry.
prohibiting, just for clarity on 32,
Uh-huh.
what the court is prohibiting is from us saying, I believe this, or this is my opinion, correct?
That's correct.
Okay, 33. Yeah, I agree with 33. No objection to 33.
All right, Mr. Sarden.
No objection.
All right, 33 is granted. 34.
I don't believe it's appropriate for a motion in limine, Your Honor. It depends on who's called at trial. I don't know. I don't know how the evidence is going to come out. It really just depends.
Mr. Sarden.
Nothing further.
Mr. Register.
I just think it injects innuendo that's not appropriate. If they start saying, well, why didn't they call so and so? There were so many healthcare providers that had, small roles in the case. We'd be in trial for 3 weeks if we had to call everybody. So to make this trial efficient, we call the people that we believe are relevant. And if there's a witness that either side can call, we can't blame it on them for not calling them.
No reason
Well,
I can't say they should have called somebody that they didn't and make that argument. I mean, that's an appropriate argument.
I think that's an appropriate argument as well, Mr. Register, as well as I think your response that we'd be in trial for 3 weeks if we called every single medical provider is an appropriate argument as well in response to that argument. So I'm going to deny 34. Failure to call, present certain evidence can be used against that party. Okay. 35.
I mean, 35 is just, I don't disagree. I agree that we are not allowed to say that Beasley Allen is this huge Alabama firm with all this resources and they could step on us as a bug. But I mean, we can talk about the presentation of evidence, how it's presented. I mean, presented, the court will give an instruction, the manner and method of testimony is relevant. I mean, I think this is a line question is what it is.
It's a what?
A line, like, are we over a line? Is it going? I think it's like I think it should be reserved. And if they think we're saying something inappropriate, they should object. I don't have any idea how big Beasley Allen really is, though, so I'm not going to talk about their great resources.
All right, Mr. Sardi.
We agree with Mr. Reynolds' position.
All right, Mr. Register.
I mean, we just don't think that the size or the ability of our law or the access to technology by our law firm is an issue. Neither would it be for us to talk about how great their law firms are or big or how many doctors they defend.
All right, I will grant 35. 36.
I mean, I generally agree with this. The only thing that I would say is if there's a medical emergency of some sort and the trial goes super long and the doctor has to miss, or one of the doctors will have to miss, I don't think we should be prohibited from explaining that to the jury. I don't see that happening in this case, but and it always happens in voir dire. We're always going to ask jurors, how does this, and we know this is an imposition on you and on the providers here of how long trial is. Does anybody have anything? I don't understand specifically what this is trying to argue, to be honest.
Mr. Sardi.
Nothing further, Your Honor.
Okay. I think I know what the argument is here, Mr. Register. I'll hear from you.
Well, I just don't want them to try to prey upon the sympathies of the jury by talking about how long it's going to last to make the jurors feel uncomfortable. And now that we have bifurcation, I do not want them to imply to the jury that they can go home sooner if they find for the defendant in the first stage.
Yeah, I've seen that. I've seen that happen before. That was really bad. But the plaintiffs did a really cool thing. They said, never mind. We don't even want to know. We're not going to even argue the portion about attorney fees. And it worked out for them. So anyway, do you have more to say now that you understand the argument, Mr. Reynolds?
I mean, I think the jury has to be told that you're going to decide liability and then you will decide damages. I've not tried one yet under this system.
Me neither.
I mean, I've tried.
Is anyone else?
Not yet, Your Honor. This is going to be the first one.
No, we're all tort reform virgins here.
Well, I've tried cases since tort reform, but we didn't ask for a bifurcation, which maybe was a mistake.
Okay. Well, that's not real tort reform then, Mr. Reynolds. Okay. Well, I don't, especially our jurors who just are very, you'll see, they just don't, they're not chomping at the bit to do jury service. So I definitely don't want to I typically tell them about how long I expect the case to last so they can plan their lives. But yeah. I definitely don't want them to think, hey, if you don't decide this part in this party's favor, then you get to go home early. That's not appropriate. And I will not allow that. Also, I think the argument, any type of mentioning of the defendants being away from their medical practices as well, I don't think is fair argument. So I guess I'm going to grant 36.
The only thing I would ask with regard to just the bifurcation, and I'm not sure. I mean, I think that I have tried punitive damage cases before, and the jury is regularly told you're not going to consider that issue right now. Mm-hmm. If you were to find one way, you'll be brought back and then that issue will be considered. I think there needs to be some acknowledgement to the jury that that's going to happen. And I'm not saying that I know how to do it right now. I'm just saying that there's got to be some way to tell the jury, you're not considering damages in the first portion and you haven't received the evidence on that. You will receive the evidence if you were to find liability, or I don't know how to tell it, but there's got to be some way to tell the jury about what's happening.
Okay,
So
I
I'm really
agree with that.
I'm just bringing it up, saying we got to think about how to do that. So
I have some other judges that should have some instructions on that. So I will start locating those, and I'll probably send out some proposed instructions on how to do that. But I don't want either party gaining an advantage from that as much as we can prevent that as possible. So that's why I will grant 36. But obviously, if it's me having to explain to the jury how this works, and then you all go behind me after I've said that in your openings and closings to explain that process to them, that would be permissible. But I don't want anyone trying to gain an unfair advantage by saying that the jury can go home if they decide a particular issue in a certain way.
37, I don't object. No objection.
Mr. Sarden,
No objection, Your Honor.
37 is agreed upon. 38.
I don't agree that any time that the court has taken anything under advisement, I need to make a sidebar with the court and say, I may go ask this question now. Will the court give me a ruling? I don't know if that's the intent of this. I mean, I think with cross-examination, that would reveal the cross before you do it. So I'm not exactly sure what this is asking, other than, I don't know what this is asking really. Is that the intent of this? Is anything that the court has reserved on that we ask to be taken up outside the presence?
No, Your Honor, I think in light of the arguments that have been made today, there are a number of matters that we talked about where he expressed concern about something, and you said, well, we'll determine that when we get there. I would just ask on the big items that we kind of know were at issue today, if you're going to go there because you believe the evidence has come in some form that allows you to, that we try to have a sidebar before we just start putting it out in front of the jury.
I will absolutely agree that to try to have a sidebar with anything that I think is like that and falls underneath that, Your Honor. I just don't think that's an appropriate thing for a motion in limine, but I don't disagree with that. And again, Mr. Register and we previously practiced, not in the exact same firm, but generally together. We've known each other a long time. I don't think this is going to be an issue, but.
Mr. Sarden, anything additional from you?
No, Your Honor.
Okay.
I don't think ours are as long, Your Honor.
I'll grant 38 generally. But I just kind of think that everyone here knows how to behave at a trial, and it's not going to become a show. 39.
There is no 39.
That was it. We're finally done with the plaintiffs.
I'm sorry. It says reservation of the opportunity to file additional motions in limine.
Oh,
Okay.
well, yeah, I guess that's,
It
that was
doesn't
just a
require
reservation.
ruling.
Yeah.
Okay. Doesn't require any ruling. I was just going with the little check marks here. The lines for check marks. Okay.
Does the court reporter, is she okay? I don't want to tax her fingers.
I was about to ask her. Miss Holloway, you need a short break?
No, I'm good.
Okay.
Good. Is everyone else good?
I'm good.
Good.
All right. We'll
Good,
keep
thank
going
you.
then. With the defendant's motion in limine, and if we can keep the same format, essentially I will allow the plaintiff to let me know if they agree or object to the motion. And if they object, I'll go ahead and hear their objection, and then I will let the defense have the final word. At least that's what I was aiming to do. Sometimes that didn't work out, but That was my goal. All right, we'll start with 1.
Are we doing mine, Your Honor, or Mr. Sarton's?
I'm sorry.
Gaddis or Schmidt?
I'm
Gaddis or
sorry.
Schmidt?
I forgot we had 2 defendants.
Your
So
Honor,
this-
we object to this one. This motion is made in every case. They try to just contain us to the word standard of care, but you can't talk about medical care, especially in a situation where the essence of the case from both sides is which decision carried more risk? Did it require her to be on anticoagulants to prevent DVT, or their argument that anticoagulants provided danger for her falling and developing a bleed? That's the essence of their defense. They say it's okay to go either way. It's a judgment call. Our position is that was totally unsafe. It was unreasonable. And a lot of this wording, this broad-based wording that they're trying to prevent us from saying is part of the nomenclature of discussing medical malpractice. We know we have to have testimony that a doctor did something unreasonably, that he did not act reasonable under the same or similar circumstances. But you can't strike out these words.
Well, the court actually can, Your Honor. I mean, the question is, was there a violation of the standard of care? The standard of care is well defined in Georgia law. It's statutory that a physician has to provide reasonably prudent care as would be provided under similar circumstances or conditions. There is nothing under the law that requires that the best care be provided, that the safest option be taken. There's regularly arguments that, what is the best option? And that's not appropriate. That's not the standard. That's not the issue that the jury is determining. The jury is determining, was there a violation of the standard of care? Does a reasonably prudent doctor under similar circumstances and conditions, can they select to do this? Questions with regard to what is the best care? What's the safest option? Mr. Register, throughout his motions, was talking about how we don't want to mislead the jury about what the law is. That's what that is absolutely designed to do. Do we want the best care? That's not the issue. The issue in this litigation is, did the care comply with the standard of care? That's why we include the specific language. It's because it's what we see over and over again. This comment, the medical provider is not allowed to needlessly endanger the public. And should they have safety standards? None of this is relevant to the litigation. The sole question, not the sole question, but the question is, was there a violation of the standard of care? Was there injury? And did the violation proximately cause the injury? Those are the issues. What is the best, the safest? None of that is relevant to this litigation.
Mr. Sarton is Ms. Griffin going to take over now? You still got the wheel.
I'll let Ms. Griffin answer that.
And take over.
Okay. Do you have any, I saw you come back in before we started Mr. Reynolds' motions in limine. Do you have any response to number 1?
No, I don't have any response, Your Honor.
All right, Mr. Register. You had your opportunity, Mr. Register, to voice your objection. I was trying to catch up and understand what you were talking about, but you mentioned something specific, I gave a specific example from the case, and I would like for you to restate that so that I can better understand your argument.
Yes, Your Honor. So I think at the heart of this issue is the jurors. So the definition of a breach of the standard of care. Standard of care is what a reasonable physician would have done. That's what our statute says. I think they would agree. What would a reasonable physician do under the same or similar circumstances? In order for an expert to talk about what is reasonable, in order for a jury to understand what's reasonable, because most of these jurors probably have never been a doctor or have never treated a pulmonary. They may not even know what a DVT or a pulmonary embolism is. They may not know how important it is to receive anticoagulants when you're unable to ambulate. So for doctors to break it down to a layperson's understanding, for an expert to explain it, they have to use terms. Now, he's thrown in some of those that aren't, he's thrown in some mean sounding ones to try to take away all the words. But doctors talk about what's the safest choice. What's the safest choice if you have two options? If you have a patient that's got multiple risk factors of developing a DVT, or you've got a risk of her falling down and developing a brain bleed. You have to weigh those risks and decide what's the safest choice for this patient. And a reasonably careful doctor, complying with the standard of care, weighs the risk. And if you have, what they're going to learn is there were multiple risk factors. There's a score called the Caprini score that says if you score a 5 or higher, you are at high risk of DVT. She scored a 21. And so what's the safest choice? And for you can't prevent those words from being discussed. You can't needlessly allow Miss Walker to go home with the high risk of developing a DVT that could kill her versus the unlikely risk, since she couldn't ambulate, that she was going to fall and hit her head. All of those words are part of the explanation in every med mal case on how to explain what was reasonable. And they don't like them, but that's part of the discussion.
Okay. I think you don't have the nice little lines, Mr. Reynolds, on your motions that says agreed.
That's
I saw those and
automatic
I was like,
denial.
I need to get them from now on.
They're so helpful. But anyway, I want to, I don't want there to be a lot of objections. So I understand that the importance of ruling ahead of time on this issue, but I just haven't had a whole lot of medical malpractice cases, and I just don't know with those terms that Mr. Register is talking about if they're going to be fair to the defense in his expert trying to explain the standard of care. I don't want to limit them in their ability to testify to the jury to explain things in layman's terms. But at the same time, I don't want there to be any confusion about what the standard of care is. So I feel like I need to just reserve this, Mr. Reynolds. And if
We'll
we,
make the objection.
okay, all right. So 1 is reserved. 2.
Your Honor, again, we have to object to this one because it is so broad that there's no way we can know what all they're going to think are gratuitous versus what our doctors talk about. I mean, as part of the failure to give her anticoagulants, Dr. Gaddis and Dr. Schmidt failed to communicate. Now, we have to be able to talk about the fact that Dr. Schmidt, who took over for Dr. Gaddis on the weekend, didn't make any attempt to call his partner and say, what's your plan for Miss Walker? His plan, by the way, was to send her home on blood thinners for 6 weeks. But Dr. Schmidt on a Sunday discharged her without them. But they didn't talk. So that's an example of what they would probably say is a gratuitous criticism, but it's merely a fact. It is a fact that they failed to communicate. And by the way, we made that, we asserted that one in the pretrial order, but I think that's something that they would say may not be a complete breach, but as part of the failure, the breach to the failure to give her anticoagulants, it was partially the result of them not talking and putting their heads together. And when she came back to see Dr. Gaddis, he didn't look in her chart to determine that she wasn't on the anticoagulants that he had planned for her to be on. So we have to talk about the other aspects of their care. Now, we can't tell the jury they should find them liable for some things, but we can't just be limited in saying, oh, you can't talk about it if they drop the ball in other areas related to Miss Walker's care.
That's the issue right there, is where he uses the word failed. He uses the word the phrase dropped the ball. The question is, the obligation in a medical malpractice case is you got to have three things. You've got to have a breach of the standard of care. Under all the law out there, it says that that's got to come through expert testimony. I'll tell you, when we talk about that jury instruction, the pattern, I'm going to ask you to remove the word usually, because this is not a case where a jury could find that you wouldn't need expert testimony. So an expert has got to testify to a violation of the standard of care. The experts have been asked specifically, what do you believe the violations of the standard of care are in this case? And the experts have given their opinions with regard to the violations of the standard of care. They should not be allowed to testify, oh, and by the way, this was bad, or there was a failure here too. Nor should counsel be able to argue there was a failure, because it wasn't a violation of the standard of care. And the issue and what a physician is required to do by statute is to provide care within the standard of care. To argue that there was a failure to do something, that they dropped the ball by not doing something, that's the problem. Those are gratuitous criticisms that do not rise to the level of a violation of the standard of care. It's not relevant what they think are violations that are not, or that was bad. That's not a violation of the standard of care.
So, gratuitous criticism, and here you define it as criticisms of other healthcare providers who are not defendants. So if there is a criticism that,
It's three. I'm sorry, can I interrupt?
yes,
I give three definitions.
I know, I'm just talking about the first one first.
Okay.
Are you saying that they have to all three be conjoined for it to be gratuitous criticism, or there's three separate criticisms that can be gratuitous?
Three separate things that can be gratuitous.
Okay. So for the first one, criticisms of other healthcare providers who are not defendants. So since Dr. Gaddis and Dr. Smith are both defendants, then there can be a criticism that one should have called the other to communicate about the patient. Are you then saying that that's not appropriate?
No, that's not appropriate. That's the second. That's why I said I defined it three ways, and that's the second definition.
Do not rise to the level of the standard of care violation?
Yeah, unless their expert were to testify that the standard of care required Dr. Schmidt to call Dr. Gaddis before making the decision, no, they cannot be critical of an alleged, nor can they say there was a failure to call him.
So do you think that, so are you saying that that testimony can't come out in this trial?
The testimony can come out that he did not. Did you call him? No.
Okay.
But it cannot be, and he failed to call him. I mean, that's critical. And an expert can't testify he should have called him. That's a gratuitous criticism. It is not a violation of the standard of care. It's just something the expert doesn't like. It's got to be for a criticism, for them to be critical of something because the issue is a violation of the standard of care. He's got to be able to say this was a violation of the standard of care. All of these experts were asked, what is the basis for your opinion as to the violation of the standard of care?
So, okay. So it's okay for him to say that one doctor didn't call the other. They can ask him, hey, you didn't call Dr. Smith, or Smith, you didn't call Dr. Gaddis. But you don't want Mr. Redisher to argue that because he didn't call him, that violated the standard of care. Or
I don't want him to say that was a failure. I don't want there to be any kind of criticism of that. If his expert hasn't offered testimony already that was a violation of the standard of care. We've all agreed no new opinions are coming in. So there cannot now be some criticism of a failure to call unless the expert has already testified that was a violation of the standard of care.
What other, I'm turning the page here. What is your case law to support this? Do you have any?
Well, I mean, we started, I didn't write this, so I don't know if Goggin actually says this, Your Honor. I know that the statute says that irrelevant testimony is
That's
not
very
admitted.
honest of you. Thank you, Mr. Rivers. Thank you.
Well, I don't mean, I assume that when they wrote it, I assume someone has read it and it is supported.
Right.
I am relying on relevance. So I think it's OCGA 24.4.402, I believe. And maybe 404, I get them confused all the time. But it is not relevant. The question before the jury is, was there a violation of the standard of care? It is not relevant what an expert is critical of that doesn't rise to the level of standard of care. It is not relevant what Mr. Register believes is that he is critical of that doesn't rise to the level of a standard of care. The sole issue in a medical malpractice case, again, not the sole issue, but the issue in a medical malpractice case is, was there a violation of the standard of care? And so gratuitous criticisms are criticisms that do not rise to the level of a standard of care violation. They're irrelevant. They are confusing to a jury. It is inappropriate. It's the same reason we argue that you can't argue the safest thing. It's not the standard. The standard in Georgia is standard of care.
Gotcha. All right, Miss Griffin, did you have anything to add to this?
No, Your Honor.
All right, I'm going to grant number 2. I don't, by granting this does not mean that I believe that this testimony should not come up, but just that the expert witness should not try to testify that these types of criticisms that do not reach a violation of the standard of care that they do. I don't want that argument being made to the jury, but certainly I think it's permissible that the parties know the full details of the case, and it will just come down to how the plaintiff is allowed to argue that information to the jury. So I will grant number 2.
Your Honor, I understand your ruling, but it's so broad. I have
It is
no
pretty
idea.
broad. I agree with you. It is.
I would respectfully ask that we approach it as we get there, because I have no idea what they think are gratuitous. I've never seen it actually granted. I've always seen it taken under reserve, because they make this in every case. But a gratuitous would be that we're criticizing him because he came in to work late for a week before that had nothing to do with the case, and we tried to make him a bad doctor, and that's a breach of the standard, or he didn't return calls on patients. To me, that's gratuitous. But when I am telling the story of the treatment of the decedent, I got to be able to tell the whole story. And otherwise, they're going to stand up every time. And that's gratuitous, because they're not going to like it if something happened that their doctor probably should have done. But that's not us saying that's a standard of care violation. That's a description of what happened or what should have happened that led to the departure from the standard of care.
That's what Mr. Register wants to be able to argue. That's what should have happened. But so that's the issue. It is, and I have seen this granted before. And so that's the issue. He should not be able to say this should have happened without having an expert testify as to a violation of the standard of care. Because Mr. Register thinks it should have happened. That is not the appropriate standard. What Mr. Register thinks should have happened is irrelevant, as his prior motion in limine about what we believe is irrelevant and should not be argued. What Mr. Register thinks should have happened is not the standard. The standard is, what does a reasonably qualified expert witness who qualifies under OCGA 24.4, it's either 402 or 404, it's the other one that from what I said. What does that qualified expert say is a violation of the standard of care? Not what Mr. Register thinks should have happened. And we have been very clear with our definition of a criticism. It's criticizing them for something that is not a violation of the standard of care.
As long as I can tell the story of her treatment, Your Honor, I mean, you can't understand the totality of the case unless you know what happened. But I'm not going to be making any arguments of my opinions. It's going to come through witnesses.
Okay, and I don't want to impinge on your ability to tell the story of what happened here. But I don't want I don't want there to be any argument that certain things that were not done here that don't reach violation of standard of care should have been done. Well, I don't want there to be argument made to the jury that because certain things that do not involve the standard of care were not done, that somehow means that the defendants are liable. It's a fine line here. I think maybe I will say this, I will consider further argument on this matter if you all can provide me some case law, some legal authority. I'll consider reconsider my ruling based upon that. I'm not at all trying to stop the plaintiffs from telling their story, but I am trying to make sure that the telling of their story follows what the law is in regards to the standard of care. So that's the best that I can make out at this point. Again, if you have further case law on this, please present it to me. I'm just trying to be fair to both sides. Number 3.
Just for clarity, Mr. Register had sent me an email, and I just want to clarify what this motion is. What I'm objecting to is a witness who is being called and their video being played. I mean, I don't disagree with Mr. Register that you could play a video to someone to impeach them, but you can't call them and play the video. I've seen before where they try to call the defendant and play his video deposition, the whole thing. And that's really what this is addressing. Either call or play a video, can't do both.
Ms. Griffin, any further argument on that?
No, Your Honor.
All right. Mr. Register?
Well, I agree that we could either call or play the video, subject to the rules of availability, but assuming everybody that shows up as we believe they will, and everybody respects their subpoenas, I don't think this will be an issue. But to the extent someone's not there, we may play the video instead. But I don't think, I think the civil procedure rules are not that strict. Depends.
Let me say this. I have seen defendants called by the plaintiff in the plaintiff's case in chief or maybe have their deposition played in the plaintiff's case in chief to establish something. And then also that particular defendant may testify in their own case. Are we talking about that, Mr.?
No, I'm talking about in plaintiff's case in chief, they can't call my client for cross-examination and play his video deposition. They got to choose one or the other.
Okay, and you agree with that, Mr. Register, or no?
I intend to call them live, but in the event they aren't available, I may play their deposition for the parties.
Well, if they're not available, then he's not calling them, so that doesn't cover the issue. The issue would be if he calls them for cross-examination and plays their video.
Yeah, I don't think I need to play their video if I'm going to call them live.
Okay, I think y'all are in agreement, but it was very confusing to me. So I'm going to grant number 3, and obviously there will be an exception made if there's impeachment, right?
Yeah,
Yes.
it doesn't cover.
Well, this order does not apply to impeachment.
Hang on. I'm
It
sorry.
doesn't apply to
I should have.
impeachment.
Go ahead, Mr. Register. What are you saying?
I think we agree this doesn't apply to impeachment.
Okay. And Mr. Reynolds, what were you saying?
I was saying the same thing. It doesn't apply to a snippet
Okay.
of the deposition.
All right. Very well. 3 is granted. 4.
And as to granting it, we can do either. We can't do both, is what you're saying.
That's correct.
I think this is very similar to what I wrote, which is we don't want it. We can't reference the wealth of these doctors and how much money they make. Now, that's different to me than talking about what their practice is like. But we're not going to get into how much money they make or how much wealth they have.
Okay.
Great.
So that's granted. Oh, I'm sorry, Miss Griffin, did you?
No.
Okay. Number 5.
So I don't think there's any way to agree to this or for the court to grant it. I mean, the only way, if we make it to damages for a family member to talk about a person's life and what their life meant to them, it's going to necessarily involve them talking about their mom loved them, their mom cared for them, and she's gone now, and she's not going to be able to come to my wedding. You know, it's just, this is so broad. It's very difficult. Now I can't talk about their injuries because that's not relevant. When I say their, I can't talk about Ken's injuries, the plaintiff as the son. I can't talk about his sister's injuries or his mother's injuries for losing her daughter, but they have to talk about how this whole thing occurred and happened, and it's going to necessarily have emotional aspects where they talk about how much she loved them and they loved her. That's the only way you can tell the story of what was important to a deceased. But I can't present evidence that Ken Wilson suffered emotional damages and wants to be compensated, or the jury should consider that in their award.
Miss Griffin, anything?
No, Your Honor.
All right, closing on your motion here. Mr. Reynolds.
That the alleged damage suffered by someone else in this litigation is totally irrelevant. The question is the value of the life to the decedent. I mean, how much I loved my mom or how much she loved me, one, it would be speculation how much she loved me. They can talk about interactions they had with her, what they saw, what she talked to them about, things like that. But I mean, their loss, and it's aimed at testimony like, I really wanted my mom at my wedding. That's not relevant. She can say, I had a wedding and my mom wasn't there. But the loss to an individual that is not, the question is the value of the life to the decedent at the time of death. It is not the emotional loss to other people. Mr. Register is highly concerned about trying to invoke inappropriate sympathy for the doctors. This would be an effort to invoke inappropriate sympathy for the plaintiff.
How are they supposed to, what do you believe would be permissible in order to establish evidence of the value of life of the decedent? And it shouldn't be hard for you to tell me that because you're a plaintiff's lawyer, right?
Yeah, I was.
Okay.
So what they can talk about is, the family that this person had, who were their kids, what did they do, what did they enjoy doing, where did they go, what were their plans, it's from the perspective of the decedent. And so, mom told me that, I'm thinking of a wrongful death case I tried against Mr. Huff, where we were talking about the dad and what his plans that he and his wife, what he had expressed that he wanted to do to her, not to her, but with her long term. That's the kind of testimony that from the decedent. Now it's definitely case specific, but with regard to, I loved my mom, it's what's not allowed is things like, I loved my mom so much and I can't believe she's gone. That is absolutely inappropriate. I wanted my mom to come to my graduation. My mom never got to meet I really wish my mom could have had a relationship with my daughter. Those are absolutely inappropriate things. And it is somewhat the distinction, like Mr. Register and the court has made with regard to argument, that I can't say, I believe this as the lawyer, but it's got to be from the perspective of the decedent, not from the perspective of the witness.
So it would be permissible, let's just say, if a family member passed away at the time one of their children was expecting their first grandchild. So it would be okay to say, my mother didn't get the chance to meet her first grandson, but it would not be okay to say, I really wish that my mom could have met her first grandson.
Correct. Yes, I think that is absolutely true.
Okay.
So we disagree with that, Your Honor, under the law, but just for the record.
You say you disagree or agree, Rob?
I disagree that in the damages phase, it would be improper for a daughter to say that her mother is not going to be there to see her child. I wish she could have been there, and I know she would have wanted to be. I mean, that's just talking about the law doesn't, they're not alleging damages. They're just talking about the impact of the loss of this person. That's how you tell a story of a decedent. We're not alleging or asking the jury to award the current plaintiff damages for that person.
So-
There is no relevance to that other than a non-presenting evidence of damages that aren't relevant to the jury's determination to gather sympathy. That is the sole reason for that.
Okay.
The only
So-
question is the value of the life to the decedent at the time.
So what I'm going to do, I think this is the type of objection that can be made on a question by question basis. And or maybe a response by response basis. I do see the distinction. There is, I think if the witnesses are properly prepared, that we can stay out of that. And I understand the difference. I know you said that you disagree, Mr. Redisher, but saying, what the impact is on the witness that's testifying that something didn't happen is different on what the impact is on the decedent.
He's going to object to the other way we ask it too, because he's going to say that she can't say that Tyrion would have wanted to be a part of the life. He's going to say that's speculation. So how do you convince? How do you tell the story to the jury of what the decedent missed if the family can't tell the jury what was important in the life of that decedent?
They can absolutely testify to what was important to the life. This is what I observed. This is what I saw. She really liked spending time with her grandkids. I saw her regularly spending time with her grandkids, and she didn't get to meet my daughter. That's how I would tell the story if I were a plaintiff's lawyer. But the comment cannot be, she really would have wanted to do this. It also cannot be,
That's
I really
speculative.
wish my mom could have done this. And Your Honor, this is
That's
an
talking about
exceptional-
impact on the witness. So
Yeah.
I see the difference. I recognize it. I'm going to reserve, but if the plaintiff can see how I am interpreting the rule, then I believe that any question that you wish, or the testimony or evidence that you wish to get out, that you can get out. But we want to keep the emphasis on the decedent and not on the person who's testifying
And
as
for
far as the impact. So
just for the
I'll
record-
reserve. I'm sorry?
Just for the record, Your Honor, this
Yes.
is an exceptionally difficult thing to object to in real time because of what the implication to the jury. So likely, if I'm going to object to any of this, I'm going to ask to approach and do it totally in private, so the jury doesn't hear us objecting to that.
Well,
That's why we make this as a motion in limine, because this looks exceptionally heartless to a jury. If a person is testifying, I really wish my mom could have met my daughter, and then I got to stand up and object to it.
I understand your point. I'm also thinking about the difficulty of the layperson not understanding why they can say something one way but not the other. Why can't I say that my mom would have loved to meet her granddaughter? But if she says, my mom was looking forward to meeting her granddaughter, she told me she couldn't wait for the child to be born. So, I mean, to me, I could see how a layperson would think those are the exact same things, but it's all in the way it's presented.
I guess that I would just ask Mr. Registrar, I think we understand the ruling. I think if you can if you talk to your witnesses and try to stay within the lines, if I need to object, I'll object.
And if I was to say this as well, Mr. Registrar, because I know that your opinion is different about that. If you have any legal authority that differs from what my understanding of the law is, then please present that to me. Because I don't want this to be a situation where someone is constantly objecting during your witness's testimony about these very sensitive issues and making this last a lot longer than it has to be. But at the same time, I want to keep the emphasis on what Ms. Walker lost and not on what her children or her family lost, if that makes sense.
It does, Your Honor, and we will do our best to stay within those constraints and instruct our witnesses.
Thank you. Number 6.
Well, we talked about this one earlier. I think it's almost the exact same thing. Neither side can talk about settlement negotiations or compromise.
So 6 is granted.
But this goes to that question of, do you take responsibility? That's what you said, that we could make the motion, and that's what this brings up again.
Oh. Okay, so we need further discussion on this?
I mean, I don't think they can ask the question, do you take responsibility? But you said I could raise it if it came up. And I mean, this is the other side of that coin, where Mr. Register said it's different about you can take responsibility.
I don't see the word, sorry, I didn't mean to interrupt you, Paul.
Says these statements suggest defendant was unreasonable and the reason why trial is taking place and the juries are being inconvenienced. And that's what the question of do you take responsibility is the reason we're here is because you're not taking responsibility for what you did wrong. That's what that question is. And if you ask that question, it opens the door to me that we made an offer to resolve this case. We consented to settle the case, and it is, despite Mr. Register's comment that it is a nothing or a de minimis offer, there would be evidence that came in of a 7-figure offer that was made.
Your Honor, there is no case that I have ever heard of where asking a defendant if he or she is responsible for causing a plaintiff's injury opens the door to settlement negotiations. That's just preposterous. We've always been allowed to ask defendants if they accept responsibility, or if they feel like they were responsible, or if their departure from the standard of care was the cause of the defendant's death. And they usually say no, but that doesn't open the door to say, well, my insurance company offered some amount.
The third question that he asked would be appropriate. The third question, do you believe you violated the standard of care? Do you believe the violation of the standard of care caused injury? That would be an appropriate line of questioning. The question that we're talking about that he wants to ask is, do you take responsibility for killing this, not killing her, Mr. Register's better than
Her
that.
death.
Do you take responsibility for her death in this case? That's what he wants to ask. Because he wants the jury to say the reason we're here is because this person refuses to take responsibility. He wants to put in that's why, and it's not relevant. And so if we're talking about responsibility, then I should be able to respond back with the attempt that they made to take responsibility. If he wants to ask the question, do you believe you violated the standard of care? I agree with them. They will testify, no, I did not. But that's an appropriate question. Do you take responsibility is not. And the time that it normally comes up, do you take responsibility, is in a car wreck case where they have denied that they're responsible. It's a completely different question of, what is the standard of care? The standard for car wreck is simple negligence. The standard for medical malpractice is a breach of the standard of care.
But the standard of care is the same as ordinary negligence. It's just what would a reasonable physician have done versus a reasonable car driver. I don't think there's a case in Georgia that has prevented asking a doctor if he was responsible for causing the injury to his patient. And it certainly doesn't open up the door to talk about stuff that's completely banned, which is settlement negotiations, offers, or counteroffers. But Mr.
Simple negligence and professional responsibility are absolutely different standards. I can send you 100 cases right now that talk about the difference.
Reasonable.
Hang on, don't talk over each other, gentlemen.
So
both standards is what was reasonable.
When I think that Mr. Register, do you equate responsibility with liability?
Responsibility and fault, I can ask them if they believe they have any fault for causing the death of Tarion Walker. because that's going to be part of the instructions to the jury to assign fault between Dr. Gaddis and Dr. Schmidt. To me, responsibility and fault are interchangeable words under the law. But if
I disagree with that, but um so okay. Um I'm going to grant 6. So I don't want to lose sight of the big issue here is that there should be no discussion of negotiations or failure to undertake negotiations of what may be made in front of the jury. Okay. Questions about responsibility, asking that in a medical malpractice case. If you all want to present to me some, what do you call it, a bench brief on that issue, I would like to look at what the state of the law is on that. I may be making small issues into bigger issues, but again, I'm trying to be fair to both sides. And when you have somebody who has passed away, and it's being alleged that they passed away because of a doctor or more than one doctor standard of care, violating the standard of care, what if they what if they say no, I'm not responsible? And so at that point, what do you think you can argue from that, Mr. Register? Because I don't think they're going to agree that they're responsible. I don't think either one of them will agree.
no,
So
we
I think
sent a request for admission on that and they denied responsibility. Now, we've
Okay.
had cases where they come to court and the defense attorney says, we accept responsibility
okay.
on the eve of court. And they come up and say, we're going to accept our responsibility. But that hasn't happened here. And I didn't want it to be, this motion doesn't even include the word responsibility, but the
It
fact that we're
doesn't.
talking about it is,
Yeah.
I think it's at the heart of why we are having to utilize the court system is the parties can't resolve a dispute. And we're here to ask the jury to determine who's at fault.
I think that what you just said is permissible.
Okay.
So maybe we don't even need to be concerned about this. Certainly, I will take up any position that the defense has that they're able to present what offer or what have you was made. I don't think that that's going to be something that I'm going to allow either. There could be a number of reasons why that still would not resolve the case. So, anywho, 6 is granted. And if we need to have further discussion about the question of responsibility, then we will. 7.
All right, I wanted to make note, we really appreciate the time that you've taken on these. I know it's taken up the entire afternoon, but thank you.
No worries.
I agree, second that.
All my pretrial conferences last a long time. I think it's just me, because I do so much thinking or contemplating while it's going on. So if you all, I'm open to critique. If you know of a way I can get through this much faster, then just let me know.
I think it helps. I think it streamlines the trial. It shows that you care about your cases and we appreciate it, even though we may not agree.
Okay, thank you.
Prior lawsuits against the defendants or prior med-mal lawsuits against the defendants or the experts, I don't think have any bearing on the case. We don't have any history of them forgetting to prescribe anticoagulants to other people that I know of. That would be the only time those would be relevant. But his statement of character evidence is pretty broad. It's just hard to agree to this and have an omnibus type ruling. I mean, there could be things that come up between the defendants as to how, how their practice works. I don't know what Dr. Gaddis is no longer there. I don't know what he's going to say about Ortho Atlanta.
I don't have any idea what he's talking about there, Your Honor. I mean, I don't, there, if it is a course of practice, if it is a habit, then that's admissible. But if it's, what did you do last Tuesday? That's character evidence, and character evidence is inadmissible. Prior lawsuits are inadmissible of the defendants or the experts. That's what this motion in limine is intended to address.
All right. 7 will be granted if there's any evidence that the plaintiff, I'm sorry, Ms. Griffin, I keep forgetting. I'm assuming you want to join in on Mr. Reynolds' motions.
Yes, Your Honor.
Okay. Did you have anything further on number 7?
No, Your Honor.
Especially not that I said it's granted, right? Okay. All right. So 7 is granted. If plaintiff has evidence that they believe that should come in, but may be characterized as character, then we will address it outside the presence of jury. But by now, you all will know if you would have exchanged all of this information and discovery. All right, number 8.
Your Honor, we agree that we are bound by the new law. Well, we don't like the law, but we're not going to challenge it in this case. But OCGA 910-184, as it has been amended, I believe we have to follow that. And he goes into great detail. And so I would agree that we have to follow the law, but I don't want to have to answer all these hypotheticals that he proposes that we may or may not say. I mean, I think I have to anchor it as required under the law.
Ms. Griffin.
I don't have any argument, Your Honor.
All right. 8 is granted. 9.
Now, Your Honor, I think that you can't limit us from arguing why something may have happened. The jury's going to wonder why it was that these doctors didn't pay attention to their patient multiple times, why they didn't communicate, why they didn't review her medical record, why they didn't do anything in the follow-up visit to realize she wasn't on anticoagulants. And I believe we can bring evidence to, or make arguments to the jury as to what may have led these doctors to be so inattentive to their patient. Because that's what, at the heart of this, they didn't communicate and they didn't realize this patient who was high risk for blood clots wasn't on anticoagulants. Dr. Gaddis, he wrote it in the hospital records 3 times that she needs to be on them. And so I don't think we can't talk about their actual money or their wealth, but I think we can talk about what may have caused these doctors not to be attentive.
It's important to listen to what Mr. Register said there. What he said there, we can present evidence, and then he corrected himself. He said, well, we could argue. There is no evidence in this case that they were doing this because of profits or that the doctors, there's no evidence of it. And so a plaintiff's lawyer cannot just argue, well, this may have been the reason. Maybe they were putting profits over patients. That's not appropriate. There's no evidence of that. And so that would get into the whole, if they were to try to make such an argument, then that would open the door to a system argument. If they were making an argument about that in this case, we would have presented evidence with regard to what's going on with the system overall. I can't respond to a there is no evidence of argument that Mr. Register is just grasping at. Maybe the doctors had other things that they were doing. That's not an argument. That is an inappropriate, it is not a reasonable presentation of what the evidence is showing to a jury. It's just speculating.
Miss Griffin.
No argument, Your Honor.
I mean, without more, Mr. Register, I'm tempted to grant 9. I don't know, because specifically they're asking for there not to be any argument made because of profits or trying to seek more profits, or what the defendant's financial conditions, that somehow is relevant in this case. But you're saying that you want to argue a reason why this happened, and I other than these doctors are careless or whatever your argument may be about that. I just don't know what that could be. I guess I don't understand.
Well, how about this, Your Honor? If you will reserve ruling on it, I will not make that argument without first seeking a ruling from the court, but I want to be able to ask questions, not a lot, but I do believe I have the right to ask the doctor about whether or not there was a motive to see more patients in order to fulfill his obligations to the practice. And depending on what he says, we may or may not be able to we may or may not be able to make that argument, but I will not make that argument without first having a discussion with the court outside the presence of the jury.
I think it would be absolutely inappropriate, Your Honor. It's never been brought up in litigation. We've asked for their allegations with regard to negligence. It's never been brought up. We would have a right to have the practice testify about what their profits are with regard to the limitations of a system, what insurance returns are. It opens the door to all kind of information that is absolutely inappropriate.
Do you have a good faith basis to ask that question, Mr. Registrar?
Yes, Your Honor.
What is it?
Dr. Gaddis left the practice because he claims that it was a fast-paced practice with too many patients, and he was unable to provide the detailed care to those patients that would have allowed him to spend time necessary to care for them.
Okay.
That's no at all indication that the practice is putting profits over patients. That's a statement that it's too fast for him and he wants to go somewhere else.
Well, I won't use the word profits. I'll just say if there was was there any pressure to see more patients?
I think that's fair argument based on their testimony. So
That's
specific,
question.
I'm sorry.
That's not what the motion is. The motion is dealing with any kind of argument to put profits over patients.
I'm going to grant your motion.
Thank you.
Okay. But I just want Mr. Registrar to know that the motion will not cover what he just said Mr. Gaddis's testimony was. If he's going to make argument based on that testimony, that is permissible, but not about profits. So we're clear. So 9 is granted.
And just to be clear, Your Honor, I don't want to misstate anything to the court ever.
Yes.
He didn't testify to that. He has published information stating that.
Has it been presented to the defense in discovery? Yes, to discovery, or have they presented it to you in discovery?
No, it's online, Your Honor. Dr. Gaddis put it online after he left the practice.
We would object to it, Your Honor. It's never been an allegation in the litigation. We would need to be able to call the practice administrator and talk about how many patients they see. It opens the door to everything in the world that is in this litigation that has not come out.
Your Honor, we join that objection.
Mm-hmm.
Your Honor, that's not even the issue today. We can cross that bridge when we get there, but he left the practice and the jury gets to know that he's no longer employed. That's why they have separate counsel.
That's not why they have separate counsel. They're not going to, it would be absolutely inappropriate for Mr. Register to say that's why they have separate counsel.
I'm not going to say that.
Hold on, please, Mr. Register. That is not actually why they have separate counsel. Just to let you know, the other issue on it is we can't just cross this bridge when we get there, because this is opening up. We're going to need to be able to respond to this with regard to the practice, with how many patients are there, what is the profit per patient, how does this impact the overall system, with the returns that you're getting from insurance, what profitability is there of a medical practice It is a system issue with how many patients doctors are supposed to be seeing. So we are going to get into the system of medical practice if this is gone into.
Okay, give me a moment. I need to cancel a doctor's appointment.
Still did.
Okay. All right. Yeah, I think that I'll reserve any additional rulings on that proposed testimony um for the trial, but I'll say at this point, Mr. Register, that's probably not gonna fly. I mean, the the whole purpose of discovering things of this nature is so there are no unfair surprises at trial, and this would essentially, you know, one party essentially making that type of statement can be unfair to Ortho Atlanta, and I don't want to go down that route, that road. If this was not, if defense did not have a fair opportunity during discovery to be able to present evidence to show the contrary.
Your Honor, that's not what happened here. There has always been a question of why Dr. Gaddis and Dr. Schmidt didn't take the time to pay attention to Terrion Walker, why no one was there on the day she was discharged, why no one reviewed or apparently was aware of her home health records that says she was totally bedbound and unable to ambulate, why no one, Dr. Gaddis included, this is throughout discovery, why when they went to his office and he saw her in the hallway, he was short with her and didn't really do an examination or look through her chart. Why? Okay. And so we fully will ask him why that happened. And the question then will be why was it because the practice was too fast paced And was it because you didn't have time to spend on every patient? And if he says yes, that's why, then he's telling the truth. But if he says no, then it's impeachment evidence of what he posted online after Discovery has closed, after he left this practice. This is something he did on his own after this Discovery in this case is closed, which verifies what we've always believed, which was he didn't have the time to take for each individual patient. Now, if he's willing to admit that in trial, when asked that direct question, then we don't have to show what he posted online. But that's impeachment evidence, John. I don't think you can keep that out pre-trial unless he testifies in opposite of something that he has already stated publicly.
I understand what you're saying. And so what I guess what I'm saying is I'm reserving my issues. I'm reserving my rulings on this particular issue to see how that evidence develops. And so, yeah, that's as best I can say about that. Because that's really, that just kind of got opened up because I asked you, where are you getting this possible argument from as to the why? There are many times there are questions in civil litigation that never get answered. I think you kind of leave that up to the jury, but for them to speculate why, based upon the evidence that that's been presented to them. But as you presented that to me, I don't want to get into the rulings of it at this point. But based on if that plays out in that way, that could be permissible. But I don't want to pigeonhole myself into that because I want to make sure that I'm making rulings based upon issues that are right before me and on what the legal authority that's going to be provided.
Yes, Your Honor. We understand. I appreciate that. I think we can show that we don't intend to get into the profits of the business or debate that issue. But that's what that motion was about, not these other issues.
You agree with
Okay.
10, Rob?
I'm sorry?
Sorry, Rob, do you agree? I moved on, I'm sorry.
Number 10.
Yes, I agreed. We would identify the site if we play anything for the jury. We will tell opposing counsel, we are now playing page 32 or whatever.
Ms. Griffin,
No argument, Your Honor.
10 is granted. 11.
Rob, Mr. Redsher asked me a question about this via email, Your Honor. The purpose of this, Rob, we're going to have a joint exhibit, Your Honor. I think we're allowed to play. I don't think we're allowed to include portions of the joint exhibit in opening. That's all it's covering, Rob.
What, did you say we are or we're not?
All it's trying to say is that we would be allowed to use portions of the joint exhibit, things that are going to come into evidence in the joint exhibit in an opening statement.
Okay. And do you have, what is your issue about preview?
Opening statement is you're previewing the evidence to the jury.
Okay, I thought you were asking me to agree to show you my PowerPoint before I do my opening statement. No.
No, it's to preview it to show it to the jury, something that's in the joint exhibit that we can show the jury. Some judges don't like that. Some judges get mad if you show things like that, and so that's why I do it in a motion in limine. I've gotten yelled at by a judge before. It was like the parties all agreed and the judge didn't agree, so that's why.
Well, the medical records are so key to this. I anticipate both sides will probably show portions of the record and other items during opening statement that we believe will be admissible during trial.
All right. So you agree to it, Mr. Register?
Yes, assuming it doesn't require me to show my PowerPoint to him before I do opening statement.
And Ms. Griffin, do you agree?
I agree, Your Honor.
And okay, so we're good. 11 is granted. You don't have to worry about me getting angry. If everybody agrees, I agree. Okay?
Good time.
All right, number 12.
He doesn't. This is a question the Supreme Court is going to answer for all of us soon, I think, Your Honor.
Well, I just want to preserve my objection to it because we know they're going to find it unconstitutional. But in the event someone was to say that I waived that right, I wanted to clearly file an objection on the record to the application of the caps. And we filed a brief today, Your Honor. It's lengthy, but as Mr. Reynolds said, this issue is pending before the Supreme Court. And we do hope that the court would not entertain any motion to apply caps should the plaintiff prevail. So we object to this.
I don't think it requires a ruling from the court, Your Honor. There's a case out there pending in front of the Supreme Court where one of the arguments was that defense attorneys waived the issue by not raising it pre-trial. We're just trying to avoid any argument that we waived the issue. That's the only reason it's filed here. I think it's also mentioned in the pretrial order for us. It's not an issue really for the court to determine it unless and until there's a verdict above, I think, $350,000 for the wrongful death.
Okay, so I think and I'm sorry, I was not aware of that case pending before the Supreme Court. I guess I've been under a rock.
Those of us that do med-mal are all on pins and needles about it, Your Honor. But I think the appropriate response is to reserve pending whether there's a verdict.
That's what I was going to say. Ms. Griffin, did you have anything else on that?
No, Your Honor.
Okay. So number 12 is reserved. All right.
Mrs. Salandy is going to take care over for me, Your Honor, as that concludes our portion of it.
You're leaving.
Sorry, if I can, Your Honor,
No. I just wanted you talk fast and your microphone is so low. So I just wanted to confirm that's what you were saying.
Yes, Your Honor, I'm going to take my son to a football game so that my wife stays married to me.
Good choice.
Thank you, Your Honor.
Have a good rest of your day. Thank you. All right, Miss Salandy, you there?
Yes, I'm here, Your Honor. And it's Miss Salandy, if you don't mind.
Oh, I'm so sorry.
That's okay. No problem.
He said it wrong, right? Did he say it
Yes,
wrong?
he did. I'll correct
Okay.
him later.
Thank you. Salandy.
Yes.
Okay. All right, Miss Salandy. All right, we're moving on now to Dr. Smith and Ortho Atlanta's motions in limine. Miss Holloway, do you need a breather?
It depends how much longer it will be.
I think these are
You
going to
should
go
take a
pretty fast.
breather.
Okay.
I'm sorry.
It's gonna go pretty fast then. I'll hold on.
That's what they always say.
I
And
know.
it's probably me. It's probably me. But we got about 8 of these. And so what we'll do, we'll take about a 5-minute break, Miss Holloway, if that's good for you. Or let's
Okay.
say 8 minutes and you'll be back at 5.
Okay.
Okay. And if no one needs a break, then let's go. We can go through these on our own to just kind of make sure we can go a little faster.
Okay.
So if there are
So
any
she's going
that
to take a break and we're just going to have an informal discussion.
well, I guess not an informal discussion, but I just want, if you already are you going to object to all of these? That's a
No.
better question.
No.
Okay. So, all right. So 5 o'clock, if you all need a break, we'll get all discussions on the record.
No, I didn't mean, I'm happy to have an informal discussion to save us a little time, but if someone else needs a comfort break, I'm happy with that too, whatever. Anyone?
I'm fine with whatever too. We can go
Okay.
ahead and have an informal discussion real quick.
I think Miss
Oh, I think she did too, Miss
I'm
Salandy.
here. No, I'm here.
Oh, okay.
Okay. All right. So hopefully, Miss Holloway, you're breaking. Okay, she's breaking. So do you know the one that any that you wanted to?
We're going to agree with number 1. We're not going to talk about their insurance unless by some way you let them talk about making offers. I don't think any of that should come before the jury. Then
No,
we're going to go down to, yeah, that's none of that should come in. You know, the only thing about number 2 we can talk about now, and then we can put it on the record, is the golden rule actually applies just to damages and injuries. If you look at the case law, it doesn't really apply to the negligent acts, if you talk about that. But, you know, I don't intend to, I don't want to cause a problem and start, you know, saying things that would get them up in arms about the golden rule. But if you read the case law, you are allowed to talk about how this would affect, what the jury would think if they were a patient. But I don't want to create error or create issues that they would appeal. So we're going to stay away from putting the juror in their own position on the case.
Okay.
So number 3, I anticipate what they are going to. We have outlined very in a lot of detail what our standard of care claims are. We do that because defense has tendencies to try to say, well, they didn't talk about that before, but you can't always, you can't always know what the expert's going to say in support of his or her theories of liability. So it's hard to just agree with this in general, but I would say that we don't intend to offer any novel, new, undisclosed, specific standards of care. I mean, there may be facts when taken in totality, or it may be testimony that comes out that goes to support it, but it's the same general standard of care opinions that we've outlined.
And that's all we're asking, Your Honor.
Okay.
So number 4, if they only said you can't say send a message, I would agree with it. But they throw in the term justice. And I don't think I'm precluded from talking about justice for this family. I can't say send a message. I think there's case law on that. But I can say that, we're here to get justice, or a jury's verdict is justice, or things along that nature. I mean, I don't think I'm not aware of any case that says you can't talk about justice.
I don't think what we're saying is that he can't say he needs to get justice for the family, or he's here to get justice for the family. What we're arguing is that he cannot argue that justice requires that that they return a verdict in favor of the plaintiff and things of that nature.
That's kind of the heart of the matter. I mean, but
Okay. I'm making my notes about my rulings on this as we go. I'm just going to make sure we get everything on the record.
yeah, we're certainly not going to say find them guilty, and we can't say punished. But I do think we can talk about justice. Now, was this the one where you guys said something about the conscience of the community? I think that's allowed. They are allowed to believe, as the jury, they are the conscience of the community. But
Where do you see that?
it was in one of these. Maybe it's not this one. It may not be this one.
Okay.
And we agree that lay witnesses can't talk about the standard of care. I don't think I would say the hearsay arguments we'd have to take up on an individual basis if those arise. I mean, that depends on whether it meets exceptions to the hearsay, and there's no way we can just rule ahead of time that something's hearsay. But I agree that the lay persons can't talk about the standard of care. And then we've already talked about lawsuits. We agree that other medical malpractice lawsuits cannot be brought up regarding the doctors or anybody's expert.
We've talked about number 7 too.
Yeah, this is them not wanting me to say responsibility. I think I'll try to get you some law on that, Judge, but if I understand your ruling, and unless I could change your mind, we'll use the word fault or liability, or standard of care type language.
And number 8 is about the damages, and we just, the same reasoning as Mr. Randall had, we put it to preserve the issue.
Yeah, that's the
Regarding the
tort,
wrongful
that's the
death, yeah.
caps. Yeah.
I'm sorry. I was making my notes on number 7. Hang on one second. All right, what did you all say about 8?
Number
8
8,
is
we've
the-
already discussed, yes, the caps on the wrongful death damages.
Reserved.
Yep.
So just quickly, Judge, historically, they passed the law on caps, you know, of all med mal cases. In 2010, that was the 2005 tort reform. In 2010, our Supreme Court declared that caps on med mal injury cases are unconstitutional because the statute violated the right to trial by jury. And so everybody, all of us, have traveled under the assumption that the statute was unconstitutional since 2010. However, recently, defense counsel have raised the issue that, well, that case, the Nesselhut case, was silent as to death claims. And they came up with the novel argument that death claims, wrongful death, came around after the Constitution. So therefore, wrongful death doesn't get the same constitutional protection as injury claims do. Now, let's think this through. If
That's the ultimate injury.
yeah, well, that's what they say, you know, but the Supreme Court has taken it, and there's actually 2 cases where one trial court agreed and one trial court disagreed, and they just heard oral argument in February, and it remains to be seen what the decision will be. But if they allow caps, then you're encouraging doctors to go ahead and kill the patient if they injure them, because if you injure them, you're on the hook for everything. If you kill them, it's only $350. That doesn't make a lot of sense to me, but I'm hoping.
Wow. Well, okay. Thanks for catching me up on that. I'll definitely be looking for that opinion.
Oh, it'll be on the front page of the daily report, one way or the other.
Absolutely will. All right, Miss Stokes. I'll see you tomorrow. And tell Miss Lawrence she can leave as well. Miss, I'm sorry, I'm talking to my staff. Miss Holloway, are you back?
I'm back.
Okay. I think we're ready to roll through these last 8.
Okay, I'll see you tomorrow, Judge.
Okay.
All right.
All right. All right. This is Dr. Smith and Ortho Atlanta's motions in limine. All right, we'll start with number 1. Any objection from the plaintiff?
No, Your Honor, we will not talk about insurance unless somehow that door is open through the defendant's other arguments, which I can't imagine will happen.
Miss, please say your name for me one more time. Salandi.
Salandi. Yes, correct.
I don't know why.
No argument here.
Okay. 1 is granted. 2, what says Mr. Registrar? Says
Your Honor, we agree we will not use the golden rule. In other words, we will not ask the jurors to place themselves in the position of the deceased or of the patient when they're talking about damages. And I don't intend, although I think I would be allowed to do it as to liability, we will not cause any delay in the trial. But this is where they talk about the community's conscience. I don't think the ruling should go that far. I mean, I don't think that we are prohibited from informing the jury that in this setting, they are the conscience of the community to determine if the doctors violated the standard of care.
All right. Ms. Salandi, any response?
No
And
argument.
I know this is Ms. Griffin's motion. I was just asking if you had any input first. So no argument?
No. No argument, Your Honor.
Okay, thank you. Ms. Griffin?
With regards to the community's conscience to determine whether or not Dr. Schmidt and Dr. Gaddis violated the standard of care, that's not the issue before them. It's not the community's conscience whether or not they did that or not. But I was in regards to this motion in limine, it's regarding I guess that was to go to damages, to say don't put they can't put themselves in the position of the plaintiff and that they're acting like they're speaking for the community in regards to damages. I hadn't considered that as part of whether or not the jury is acting as a community's conscience for whether or not Dr. Schmidt and Dr. Gaddis violated the standard of care. I don't really understand what he means by that.
Well, in any case, the jury's verdict sets a precedent. It is a standard by which the community will look at the actions of their doctors. I mean, that's a common theme in cases, is that the jury is determining whether or not the doctor's conduct was within the standard of care of what a reasonable doctor would do. And they have been selected as the members of the community to make that decision.
Okay, I don't disagree with that. That's
Okay.
fine. If that's what he's referring to, we can take that part out.
Okay. So, and I was just looking as you guys were discussing, there is a case, Hildebrand v. State is a 93 case where basically the court has found that the conscience of the community argument can be made in closing. So 2 is granted except for conscience of community. All right, 3.
Your Honor, we agree not to bring any new novel theories of liability, but this is such a broad motion. I think it needs to be taken with care, because in any med mal case, there's a lot of facts that are argued back and forth, that experts have to respond to what some other expert says, because their expert might say something that our expert has to respond to. But generally, those things that we've outlined in detail are the standard of care breaches that we intend to present, and we are not aware of any novel, brand new, totally new theories.
Ms. Salandi?
Nothing here, Your Honor.
Ms. Griffin?
No argument, Your Honor.
All right. So 3 will be granted as to new theories of liability. The court, of course, if there's any, I guess the court will take under advisement, or parties can object as to other matters they believe would violate this motion in limine if that comes up. And so specifically what I'm thinking about that Mr. Register just said, if, for instance, one expert is asked his opinion about something another expert said, and it's kind of spur of the moment type of opinion, that's not a new theory of liability. But if he's being asked posed a question about something, and that I feel like would be an exception to this motion of limit. So, but that will be granted as to new theories of liability. Number 4.
Your Honor, we agree that we can't argue send a message, but I think that we can talk about justice in the case.
Ms. Salandi?
No argument, Your Honor.
All right, Ms. Griffin?
Your Honor, the only we brought up justice, or meat and justice, or justice requires that the jury return a verdict in favor of the plaintiff, because these arguments lend to a punitive aspect of the case, like they're punishing Dr. Schmidt or Dr. Gaddis for something that they did that was willful or wanton conduct, when this is a negligence case. We think that it's prejudicial to say to send well, he already said he can't say send a message, but to seek justice or justice requires or this meets justice, it allows the jury to infer that they are putting punishment on the doctors, and we think that's impermissible.
I disagree about that. I'm going to grant 4, but the plaintiff may argue about justice prevailing. I mean, a lot of times I think when people hear the term justice, they may think about criminal case, but this right now, we're participating in the civil justice system right now. So our justice system is not just open to criminal cases, it's open for civil as well. So I will grant 4, but I will find that the plaintiff may argue about justice prevailing. Okay. 5.
Your Honor, we agree that no lay witnesses can talk about the standard of care. I just think it's impossible for a court to rule on hearsay at the moment without hearing the question and then ruling at the time.
Ms. Salandy,
No argument.
Ms. Griffin.
I agree, because I think it says without exception in the motion in limine. If there's an exception, then we would just make the objection at the time. But to elicit hearsay, we think is impermissible.
Okay. I will grant number 5, the hearsay objections, I guess, will be made on a case-by-case basis. Number 6.
We agree that no evidence of any other medical malpractice suits against the defendants or anyone in their group or the experts should be admissible. Prior med mal actions or future ones should not be admissible. I think they went, yeah, that's what it.
Ms. Salandy,
No argument, Your Honor.
Ms. Griffin.
No argument.
All right, 6 is granted. 7.
And just, Your Honor, that's as to med mal lawsuits. I mean, I don't think there's any other that, right?
Right. We talked about this, but this was the same as Mr. Reynolds number 6.
I'm sorry, what are you talking about 7?
Well,
Yes.
I was just clarifying 6 was any other medical malpractice lawsuits.
Oh, okay, yes.
Yeah. Okay.
Hang on. What other kind of suits would come up? Like, why would any other lawsuit be relevant or claim?
There might be an occasion during the trial where another one would come up depending on the testimony of the defendants for impeachment
Are you
purposes.
talking about the current lawsuit that's pending with Dr. Gaddis against Ortho?
Dr. Gaddis has filed a lawsuit against Ortho Atlanta, Your Honor, that is hundreds of paragraphs long, and to the extent that they provide testimony that may be inconsistent with the allegations he has asserted in his complaint, there might be an opportunity for that to be used as impeachment, but we would approach the court before we just put it in front of the jury.
Ms.
Well, Your Honor,
Salandy?
I would object to any portion of that coming in. I don't know how it's relevant how it would ever be relevant, and what could be inconsistent in his allegations and his complaint that has to do with a medical malpractice case. It has nothing to do with it at all.
No argument, Your Honor.
Your Honor, he makes a number of accusations against Ortho Atlanta in that lawsuit, some of which go to honesty and integrity of that practice. We will tread lightly there, but depending on the answers of the defendants at trial, we would approach the court outside the presence of the jury if we intend to impeach him with that.
Okay. Um, I'm granting 6, but if the plaintiff wishes, I don't know. I guess I'm granting 6. And so if the plaintiff seeks for the court to reconsider 6 for any reason, because I'm reading suits is suits. And so if the suit is attorneys draw lawsuits, so I don't know how that can work, but I don't want to spend time here getting into possibilities. So um so if you're thinking about going down that road, then we need to take that up outside of the jury's presence.
Yes, Your Honor.
All right. Before you do that. All right, 7.
7 is to take responsibility one, Your Honor, that we spoke about before at length. I think with Mr. Reynolds, it was his number 6.
Mm-hmm.
You granted that motion.
I was just seeing if there was any additional argument that anyone wanted to make on the record.
Well, his was as to something else and he actually alleged it included responsibility, but the word wasn't in there. His was as to, so this one actually talks about responsibility. And I would just ask the court for an opportunity to see if I can find you any law on that one. And we won't use that term unless we get a ruling from the court, but it has been a term that has been used frequently in many, many trials when it comes to negligent or professional negligent acts. And it has been used by defense when they do take responsibility. So I'm confused as to why and I need to read this case that they cited, but I'm not aware of any law that says you can't ask a defendant if they were responsible for the injury they're alleged to have caused. But I will come back to the court if the court would allow me and see if I could change the court's mind.
Okay. Miss Salandi, anything else on this
No, Your
matter?
Honor.
Okay. For number 7, I will grant it, but it may be reconsidered based upon presentation of relevant legal authority to the court.
Okay. And then 8, Your Honor, is the same as before we ask you to reserve ruling as we await the Supreme Court's decision.
And this will be reserved as well. Number 8 is reserved.
Your Honor, we have a couple of real quick housekeeping things if we can.
Sure.
Sure. I think that's all the motions for now, unless, did anyone have
Yes,
any?
we don't have any other motions.
Okay. Your Honor, Larry Goldston here, my partner, law partner, we have submitted everything. The bar has approved his pro hoc. We would ask the court to sign an order so that we're all set with him assisting in the trial of the case.
I thought that I had done that already. Let me.
And you may have. I apologize if I missed it. My paralegal probably texted me right now if I got that wrong.
No, I mean, no worries.
And we
it
could
was brought
submit
to
one
my
if it's
attention
easier.
yesterday. What you say? I'm sorry.
And if need be, we can submit a proposed order to make it easy on the court.
Mm-hmm. Yeah, my staff's gone for today. I know they saw that. Please submit that order and we'll get it filed tomorrow.
My paralegal says we submitted it with a letter from the state bar. So the filing that includes the state bar has a proposed order with it. I think she filed that in the last 2 days.
Okay, I will pull that off then. No need to do anything else. I'll get that. I'll take care of that.
Okay.
Okay.
Mr. Reynolds and I had agreed that he would find out the name of the reinsurers for Mag Mutual so that if need be, we can qualify the juror to those. He's not here today, but I'd like to reserve an opportunity for us to discuss that before we instruct the jury. We would either amend the pretrial order or have Your Honor just qualify the jury as to any other insurance companies that have a financial interest in the outcome of the case. As to
Okay.
voir dire, do you have, what is the court's desire for voir dire, and generally how you want us to do it? How much time do we have? I'd like to get it done, in one day, assuming we can move quickly, but whatever, we'll move at the court's pace. I didn't know if you had time limits or how you prefer to do it.
I don't have time limits, but well, I don't have time limits for civil attorneys. Okay. It's you all generally know what you're doing and you don't waste a lot of time. Give me 1 second. I meant to ask, did did anyone have an objection to the motion for admission for Mr. Golston?
No,
No, Your
none
Honor.
from us, no.
Okay, I just want to be sure. Okay, as to Vardier, so I have a kind of an interesting situation set up for Monday. Your your start time says 9 o'clock, but I don't know. I thought that I told somebody that you should not report until like 1:30 or 1 o'clock. You can actually report earlier than that. You can report at 9 if you like, but I have a couple of criminal cases that I need to resolve that morning. And it's basically a criminal calendar call. It's very short. Well, it should be short as compared to other criminal calendar calls. And I have to do that because, I set aside this time, and then what you always do to me, what we settled. And so then I'm left with nothing to do. So this was sort of my insurance policy, that I had something to do in the event that you all resolved your case. And so now it's coming back to bite me. But if you all can get there at 9, I know there may be some things that you want to set up in the courtroom and what have you. Actually, I can probably get my assistant to let you all come in when they get in, maybe about 8:15. That way you can set up everything, and as soon as I get done, if I get done with those cases it's only a 9. If I get done with those cases by 10 or 10:30, then we can get started a little earlier. Also on Mondays, that's the day when we check our jurors in for the week, and it is very chaotic, and it is very unusual that we will be able to even get a jury pool up before 11 a.m. It just takes that long to get them all checked in for all of the judges that are having trial. And so it's just a bit of a nightmare. So I would like to get done in one day as well, but that may not happen here.
What time is it known what time you want us there? I wasn't sure.
Well, what I was saying is you can get here as early as 8:15. I can have my assistant let you in, and you all will have full access to the courtroom. But we may not start addressing things until after I finish that calendar, which I hope to get done as soon as possible.
But that might be noon, 1 o'clock.
Might be, but
Right.
I don't think so. And I'll tell you how many cases I have on it right now. Well, I'll look that up while you ask your next question. Generally, I'll tell you this while I'm looking this information up. Generally, I will bring up about on a civil jury, I'll generally bring up about 35 jurors for Vardier, and we can go from there. If we need to bring up more, we can. Let me see. It's been a long time since I had a civil case. So you all need 12 jurors, and I like to choose 2 alternates. I don't know if you all have any preference on that.
Well, we would like to as well, Your Honor.
Yes, Your Honor. That's what we all requested in the PTO.
Okay. As you can see, I've read it fully. I will read it. What else?
And then how do you do it? Can we submit a question, a short questionnaire? Or do you ask questions and then we each kind of do our thing for a little while? And then how do you like it?
So typically I will ask the qualifying questions to make sure that the jury is statutorily qualified. And so the questions that you all probably have already in your pretrial order. So I'm sorry, I was trying to do two things at once. And just any other questions that need to be asked to just make sure the jury is statutorily qualified. And after I finish that, I let the plaintiff take over. You can ask your questions and then the defense. Since we have two defendants here, can you all please remind me of how that works? Because I just, quite frankly, I can't remember right now.
Well,
I think everybody gets a turn, right?
Mhm.
yes, everybody gets a turn, but each side has the same number of strikes. So they have to share their strikes.
Mhm.
So 6 strikes on each side.
Yes.
Okay. I got 29 people on the calendar Monday, but that's gonna go fast.
Okay. And then you would have us, after you ask the questions, you would have each side make their presentation and ask questions and get answers. And then when all three of us have gone, do you then allow for us, if we have some specifics to jurors that are really concerning, can we bring them in individually or bring a row in individually to ask a few individual questions that we may not want to ask in front of the whole panel? Or are you okay with us just kind of quizzing them in front of the whole panel?
Typically, after you finish your general questions for each side, I'll let each party ask any individual questions of each juror, and we would just do that in the
While
same
they're still
proceeding.
sitting there?
Right.
Yeah,
If there are any questions that a potential juror does not wish to answer in front of everyone, then I'll make that announcement, and if we need to bring them in separately, we would. But no, I don't bring in rows separately, but I do allow you individual questioning of each juror.
What about if a juror says something that's kind of outrageous and we don't want to tip off the other people that if they say that too, they can go home? Can we hold off on that one and say, Judge, and maybe bring that individual person back and test to determine if the juror can or cannot serve? Or do you just want us to do it right there in front of people?
Well, I don't usually excuse jurors, well, unless they're excused in the statutory qualification period. But I don't usually excuse them based upon that until, at the end when we're striking for cause or something of that nature, after you've exercised your peremptory rights and after we struck for cause. So are you saying if somebody says something that's just crazy and you want to stop questioning of that person in the presence of other jurors? Is that what you're saying?
Well, let's just say somebody says, a doctor saved my life. I could never find a doctor negligent, ever. You probably don't want Larry or I at that moment to say, well, Your Honor, we'd like to have this juror excused. Or Salita may want to have an opportunity to say, well, can you set that aside and be fair? But usually if we do that in front of the jury, it can be contagious. People can start saying things that they think might get them out of it, especially if they know it's a 1-week trial or something.
So are you saying that I'm not going to excuse that juror at that moment because the defense would have the opportunity to rehabilitate that witness in that scenario, but if you felt as though you wanted to continue your any questioning of that juror outside the presence of the other jurors, then we can wait till the end to finish their individual questioning.
Yeah, we would finish ours, they would do theirs, and then I guess if there was if it was uncertain as to whether that juror could be fair, we could bring hopefully won't be too many of those. We could bring them back in and have a brief questioning of them outside the presence of the others.
But that's fine. I guess I'm just kind of confused about the timing of when you think that should happen. So in your example, if you're questioning a juror and they revealing your questioning of that juror, that I could never rule against a doctor, or find, the doctor did anything wrong. Are you saying that you want the defense to be able to go ahead and ask their individual questions and then rehabilitate outside of the presence of the rest of the other jurors? Or how are you saying?
If I left it, I mean, I could probably, they're going to want their chance. So then we would be done at some point. They would then ask their questions. And then at some point we're going to need to move the court. But oftentimes there needs to be follow-up. That person may say, well, yeah, I could set that aside, but and it could go both ways. They've expressed such a bias, that I would say, but we would like an opportunity to explore that a little bit without doing it prolonged in front of the entire jury, if possible. I mean, I don't want to.
Go ahead. I'm sorry.
Well, I don't want to delay the process. We really want to get going, to make this trial efficient, but I've seen that happen. And I just didn't know if you had a preference on how we handle jurors that may have expressed bias to the point of being excused for cause, or if we just get one go round at it and then we try to all remember what they said, before we move for cause.
We can. I'm not going to say that I won't allow you to bring them back for additional questioning, but I will say, you just have to be efficient. And so if you want to invest that time in hanging on and trying to, rehabilitate a certain juror, what we're dealing with as far as our time constraints are concerned. So,
Larry, sorry, Your Honor.
Yeah, no, it's fine. So I won't say that I won't do that, but I'm not going to do that for every single juror. That's not going to work because we won't have the time to do that.
Okay. Larry, any questions about how we're going to do it?
No questions here.
Okay, that helps, Judge. Thank you. Because we are really going to try to be efficient. I've got my two experts out of state that I'm bringing in. I'm now a little worried that we may not be able to get to many witnesses on Tuesday. I was hoping we could do voir dire and openings on Tuesday. My point is, I am working to schedule around their busy schedules, and we've got a timeline that we are trying to keep our efficiency. And in every med mal case that I've been a part of, the plaintiff can call the defendant doctors for cross in our case in chief. Mm-hmm. And the defense doesn't get to direct them then because we can't control how long they're going to direct them, but they get to do that in their case. And so I would hope we all agree on that. Otherwise, we got to argue.
Yes.
Yeah, we agree.
Okay. And then, Your Honor, they do have separate counsel, but there has been no cross claims or no adverse assertions by one doctor against the other. So we would ask that neither defense attorney gets to cross the co-defendant during our case in chief. That, to me, that's kind of just letting them have a bite at the apple they normally wouldn't have. This is not a case where they are alleging negligence on each other.
What's the
what you're saying that we can't cross Dr. Gaddis? Is that that's what you're requesting?
Yeah, you guys can't cross the other doctor. You guys have shared interests. That would just be like, I mean, they had the same attorney up until discovery was closed. And that would just essentially like we have two parties. Ken Wilson is the estate and we have the wrongful death. If that were true, then I could hire another law firm to represent the estate, and then they could cross-examine Ken. They could cross-examine the plaintiff's witnesses, which would be in violation of what we all know is the standard presentation of evidence. You can't cross-examine your own party. And Dr. Gaddis and Dr. Schmidt were employees of Ortho Atlanta. They have the same shared interest. and they don't have any claims against each other. They're not blaming each other.
No, we're not blaming each other at this point, but I wouldn't agree to that until we hear his testimony. I don't know what his testimony is going to be when he gets on the stand and testifies. I have never represented Dr. Gaddis. They did have one attorney prior, but they don't now. So I've never represented Dr. Gaddis. I don't know what he's going to say, and I don't want to limit my ability to defend my client based on the fact that I think everything is going to be copacetic, I guess.
Well,
Yeah.
she would get a
I
chance to
agree with
cross.
Salida.
I'm sorry, go ahead. I didn't mean to interrupt you, Michelle.
You're fine. I was just saying that I agree with Salida.
Well, Your Honor, I would ask that you reserve ruling on it till we see what they say, but they shouldn't be able to cross a co-defendant, in our case in chief. Now, they could cross him after he does his direct, if they wish, in the defendant's case. But that's the same as what we just talked about. If they start crossing each other, then they're messing up our whole timeline in the presentation of plaintiff's case. They're going to get a chance to do it during the defense case, but that's like they're trying to create a loophole, and you would encourage every multi-party defendant to get separate counsel so they could do that. And that would be the same as the plaintiff tried to get two attorneys and could cross-examine the plaintiff's own witnesses. It violates the essence of the law on that.
I'm making a note about this, so because I want to research it, because I don't remember how that was handled. In the Mal case that I had back in 2018, there were really about 6 different defendants, 2 corporate entities, and 4 medical professionals. So I just don't recall. And if you have any legal authority that you want to present on that, because what your argument is logical, it makes sense to me. But I just want to make sure that it's supported by the legal authority.
Yes, ma'am. Or yes, Your Honor. We will look for that for you. I'll tell you. I've read about that case and talked to the attorneys. That case was a little different because they were making allegations against each other, and one of the defendants had his answer struck. One of the companies.
Yeah.
So they had a reason to cross-examine each other. This case does not, absent some change in their testimony at trial.
Okay. You've done your homework, Mr. Register.
Well, just trying to be prepared, Your Honor.
I
These defense
appreciate
attorneys
that.
they're great lawyers, and we've got a great challenge ahead of us. Let's see if there's anything else. We're going to also ask, because Piedmont Healthcare bought Ortho Atlanta, I believe that's true, and is now controlling Ortho Atlanta. We're going to ask the jury to be qualified as to Piedmont Healthcare. We can talk about that the day of trial with those reinsurers, but I wanted to.
Is that on the is that in the pretrial order?
It was not at that time because we didn't think about the fact that Piedmont now owned them, but we'd like to ask, but we did reserve the ability. Paul agreed he would identify other parties that had a financial interest in Ortho Atlanta and Mag Mutual.
Okay.
We didn't specifically talk about Piedmont, but I would hope that would fall under the same umbrella. We don't want any Piedmont executives on the jury.
What about folks that have been treated by Piedmont?
Well, they can be the judge, but not a jury.
Okay. Anything else?
I think the last thing is, I think everybody will probably file that Rule 22 motion for early entry, but you said we can coordinate with your folks to organize that, and we're going to have a lot of time that day.
Yes, I'm going to work. Since I see this case is not going to settle, I'm going to talk to my criminal folks and see if we can kind of cut down on the number of people who are having to show up that day. Or maybe if they say they want to enter some pleas, I can set them on other days. So I'm gonna do everything I can to get to you guys as fast as I can that day. But yes, you absolutely can come in.
How long do we go each day when we're full speed?
Well, I'm thinking about, I have some things. That might be the week after. Give me one moment. I usually go at 5 because I know people have to pick up kids. Like today, that was my staff attorney's issue. She had to pick her daughter up. So I don't want to inconvenience folk, but at the same time, I don't want us to be in a situation where we have to try to come here on a Saturday or this extends outside of, to the week after. I'm checking. I could go to 5:30 on Monday, Tuesday. Wednesday's a bad day. I may have to reschedule a dentist appointment that day. I could go late on Thursday, and I can go late on Friday. I'll have to reschedule some stuff possibly. So, 5:30 is probably as late as I want to go, but again, it really depends who's on the jury. If we have somebody who absolutely has to be gone from here at 5 to pick their kids up, I don't want to penalize them like that. So it kind of depends on who you choose. So maybe you all take that into consideration when you're questioning your potential jurors.
Okay. I really believe this is the last question. Are we allowed to bring cell phones in your courtroom as long as they're on quiet? I mean,
yes.
Okay. And then do we need to list specific technology or just coordinate with your clerk? We're going to try to use the court's technology, but there may be some things we need to hook into it. So,
I need to just ask my my staff attorney or my judicial assistant for our IT person's contact information, and he should be available here to help you with any of the courtroom technology on Monday morning.
And the parties had agreed, subject to your honor's approval, that if something happens, a witness is rescheduled, like I have a doctor come in on Tuesday, and if we don't get to him, he has to go back, that we would agree they could testify live by Zoom if they, unfortunate circumstances. Is that okay with the court? We don't intend for anybody to, but if something happens, I'd rather not pay another 10 grand to have them fly back.
I hate Zoom.
I don't like it either, but,
I'm on it right now with you all because I don't want everyone having to come down here to see me, but let's just make that, especially for witnesses and the jury. It is. I hate to even say that because I feel like you might tell them, well, hey, if you don't make it back, it's okay. You can appear by Zoom. And I desperately do not want that to happen. Like, it is
it's
major.
only one witness for me. It's my cardiologist, and he can come on Tuesday. He can't come on Wednesday, but he could come on Thursday. But it's just gonna be tough. He'll be here on Tuesday, but now that you told me we're starting late, I don't know if we're gonna get the witnesses on Tuesday. But I'll try, Your Honor, to get it back.
Well, what is the opinion of everybody else?
We did agree to that when we were discussing the pretrial order, if someone needed to, if they were unavailable, to allow them to testify via Zoom. We have no objection to it if that's an issue for him.
Yeah, agreed.
I want to try like hell to get rid of those criminal cases on Monday because I hate Zoom. So I will say yes, but it is a very, very, very reluctant yes. Okay.
If we can start on Monday with voir dire, it won't be the problem. But starting at midday is going to be tough. But you said the jury may not be ready till 11. But
yeah, we'll do everything we can to do that, to accommodate you.
Well, we'll move as fast as we can with voir dire. I'm sure that they won't object. We'll just take the first 12.
The first 14, huh?
Oh, 14, yeah. Okay,
Well,
thank you so much, Your Honor. Anything else from anyone?
No, Your Honor, I don't have any questions. I think you all covered everything.
Okay.
Thanks,
Yeah.
Rob, for being so thorough.
Well, I really appreciate your time. Most judges don't do this, but I think it's incredibly helpful. Thank you.
Really?
No, I mean, they try, but you really care, and you really are, trying to give us good instructions, and it eliminates a lot of fights at trial. So,
Okay. Miss Salady, anything else?
No, nothing here. Thank you, Your Honor. Appreciate it.
Okay. I'm going to be a bit more prepared. I thought that my situation about telling y'all about my doctors, I thought somebody was gonna have me recused. I honestly did. So I was like, I won't be trying that case next week. So you all really surprised me, and I appreciate that faith in me. I do. Because recently I had a similar situation happen where my legal assistant, judicial assistant went to church with some defendants who one of them was deceased. So she knew the defendant was deceased. They had not filed a substitution of party in the case. And when we let them know that, hey, she goes to church with one of the defendants, they wanted me off that case, you know? So I'm like, well, surely this situation will result in the same way. And it just didn't. But I appreciate the vote of confidence in me. And we're going to get this matter tried and hopefully to everyone's satisfaction.
Well, thank you, Your Honor. We'll see you on Monday.
Okay. I'm going to sign that order for you, Mr. Golston, and we'll get that filed tomorrow.
Thank you, Your Honor.
Take care.
Thank you all. Have a good day.
Thank you.
All right, bye-bye.
Bye-bye.
Thanks, Ms. Holloway.
You're welcome.
Hopefully they remember to pay you.